Yes, Mr. কি বদলি করলে পড়ু বললে খাইলে না থাকি Good. Yes, ma'am.
This IA is for correction of typographical mistake.
I have similar prayer for correction of the losses.
Great. It's fine. Yes. Just switch on that mic.
May I be your
Huh?
I beg to mention item number 36 and for a respondent number 9 and 10, my lord. I have taken consent from the other side, my lord. My senior is under brief, my lord. So I beg for examination. Not on the 6th, my
Senior is
yes, what happened, my lord?
what happened?
This father died. My lord.
Oh, okay.
My lord,
Mr. Fukan, on that count, we will have to
August,
adjourn.
you have taken my lord, consent.
As prayed for by the Mr. As prayed for on behalf of Mr. S. Botaku, who is said to be on bereavement, comma, not objected to by Mr. A. Fukan, learned counsel appearing for the petitioner. The matter stands adjourned. Also, registry to list this matter again on.
Can I apprise the court master regarding the after the release also?
Huh?
Can I apprise the date after sometime the court master also? I need to take consent from the senior counsel regarding the next date also. If your lordship allows me, I apprise the date of the court master.
Okay, okay. Registry to list this matter again on dash. Huh? Full stop. You just inform a counsel. Okay.
One more pair in respect of item number 52 also.
50?
52 also. I have taken consent from the other side.
Okay.
Similarly.
It will okay. On the prayer of the learned Mr. S. Botaku, learned counsel for the petitioner, who is stated to be on bereavement, list this comma. The matter stands adjourned today. Registry to list this matter after 2 weeks. 2 weeks on a date to be fixed by.
Hello,
Lordship, in item 36, there is an interim order.
The 36, the interim order.
36.
Interim order shall continue till the next date of listing.
DPO, may I please, Lordship? With a concern of other side, documents for item number 41. Lordship. In this case, we have recently entered APS Lordship for response 2, 3, and 4. Also, may kindly grant us 4 weeks time for filing our affidavit. We have fixed that because the petitioner has.
A. Sharma is in both sides or do different persons.
They are
I am for the petitioner, my lord. The date will be
Okay.
fixed, my lord.
On the prayer made on behalf by Mr. K. Kolita, learned counsel appearing for the respond number 2, 3, and 4, and not objected to by the learned counsel for the petitioners. Registry to list this matter again on. List this matter after 2 weeks on a date to be fixed.
After 4 weeks, Lordship.
3 weeks, my lord.
3
It's already
weeks.
The one.
3 weeks. 3 weeks. 3 weeks.
Hello, Lordship.
Not by me.
Item
16 and 17.
Yes, ma'am.
Item number 16 and 17. List before any other bench without me. Munam to litigate.
My lord, one more mention, my lord, item number 9, my lord. My lord, in this matter, my lord, the petitioner challenged the departmental proceeding. Now he has been allowed to go on voluntary retirement and he has been allowed, my lord. So the matter has become infructuous, my lord.
Mr. D.P. Bora, learned counsel for the petitioner, submits that during the petition pendency of the present proceedings, the petitioner has been granted reliefs. Accordingly, he submits that the present petition has become infructuous. So, prayer accepted, petition dismissed as having become infructuous.
And my lord, item number 15, my lord, in item number 15, my lord, the government has filed an affidavit, my lord. We need to file a reply, my lord.
We will consider it today only. Affidavits were filed long back.
Yes, my lord.
And what is your case? You are for the husband. You are the petitioner, the
Yes,
person, personal. 2 grounds.
It is, my lord.
Wait,
Dismissal
2
from
grounds
service.
against you. 2, I know. 2 grounds, 2 allegations. One is 3 lakhs.
My lord, that.
Wait, one is 3 lakhs,
Yes, my lord.
one is that second marriage.
Yes, my lord.
Whatever materials have been brought on record, your second marriage is established. You have resorted to forgery.
My lord,
Being a person of a defense force, we will not permit that.
my lord, the person we could not contact him, but we have issued
Forget
a
it.
letter, my lord.
We will consider this. You be here. But
Obliged,
these matters will not be adjourned.
Yeah.
Nothing is there.
obliged.
Because that 3 lakhs thing, they have not even proceeded against you.
Yeah.
While going against that 3 lakhs bribery allegation, this came into notice. And your plea we will not accept because the other personnel, your wife, second wife, she is also an officer. And in her records, you are the husband. And these cannot be coincidence. So we'll give it a closure today. Yes. Huh? Okay. Yeah. Yeah.
Delivery of order item 1.
Mr. Purkaiso, we'll uphold that, but to that extent, the order wherein your qualification has been wherein your qualification has been held to be invalid. Wherein your qualification has been held to be invalid, that we will interfere. But otherwise, following Jagannath Pegu, we will hold that you don't have any right.
My lord, I have filed one additional affidavit, my lord. The lord-
Therein, because they have given the instructions on record. Your graduate, okay, let's go by your thing. You say you are a graduate of 2011. 17 years, it will be in 2028, not in 2024. So how can we, you're not qualified. But that part of the order wherein they said that the degree, MA degree is invalid, we'll interfere.
I'm-
Tomorrow, if some situation comes in, that will help you.
Presently, I'm holding the academic charge of the.
That is it. That you hold, continue. We are not interfering.
Well, I have been declared, my lord, trained graduate teacher since 2011.
But now that that trained graduate teacher is declaration in the elementary education
Yes,
department. How can that be converted to a declaration in the secondary education department?
Right.
You have been given 8,700
even from 11 years, 17 years will be.
in 2028.
Yes.
So I'll not go into that. I'll just say that and then close it. But I'll interfere with your that other part. Wherein they said that you have that Thaneswar Nath judgment. Have a copy. Thaneswar Nath. Okay, no need.
It is
We'll
there. I think it is there.
It's not here. It's not here.
Another.
The other cases. Okay, fine. Heard Mr. Deep. We'll pass a short order. Deep Purkaiso, learned counsel for the petition, and also Mr. U. Sharma. Where is Mr. U. Sharma? We'll put his name because he was there. Mr. U. Sharma, learned standing counsel, secondary education department. The grievance in the present, the petitioner by instituting the present proceeding has presented a challenge to an order dated 4/11/2023 passed by the Director, Secondary Education Assam, rejecting his claim for holding the charge of the post of principal of Dr. Zakir Hussain Higher Secondary School. Full stop. Facts. Full stop. The petitioner hearing was initially appointed as a Hindi teacher by the District Elementary Education Officer, Kamrup, via an order dated 15/9/1993 at Dr. Zakir Hussain, MEM. Also, the said school was thereafter amalgamated with Dr. Zakir Hussain High School under the Shiksha Kshetra scheme, via an order dated 16/6/2017. Also, the petitioner accordingly was included as a teaching staff in the said high school. Also, thereafter, the said school was upgraded as to an higher secondary school and named Dr. Zakir Hussain Higher Secondary School, and the petitioner continued to figure in the list of teachers working in this said school. Full stop. Subpara. It is to be noted here that the petitioner claims that in the year 1992, he had acquired his Bachelor of Arts degree from Guwahati University and thereafter had also acquired his B.Ed degree from the same university. Also, the petitioner thereafter pursued his Masters in Arts course from K.K. Hendick State, Krishnakanto Hendick State Open University and completed the same in the distance education mode in the year 2022. Also, the petitioner further contents that the elementary education, the authorities of the elementary education department, in consideration of the Madhyama Visharad degree possessed by him, had declared him to be a trained graduate teacher, and accordingly his grade pay was also increased. Also, subpara. The post of the Mr. Husso, in the said higher secondary school, one Siddiq Ali Ahmed was senior to the petitioner, and on upgradation of the said school to that of a higher secondary school, said Siddiq Ali Ahmed was allowed to function as its principal in charge. Full stop. Said Siddiq Ali Ahmed retired from his services on 31/3/2023 on attaining the age of superannuation. Full stop. The date of superannuation of said Siddiq Ali Ahmed being approaching, the petitioner approached this court by way of instituting WPC number 5077/2022, claiming that he be allowed to function as the principal in charge of the said school on retirement of said Siddiq Ali Ahmed. So this court, while order dated 17/2/2023, on considering the issues arising before it, was pleased to hold that the writ petition was premature inasmuch as the post of principal in the said school had not fallen vacant on this said date. So, subsequently, the Director of Secondary Education Assam filed an order dated 10/4/2023 on examining the educational and teaching experience of the teachers working in the said school, having found that none of them were eligible for being posted as the in-charge headmaster principal of the said school, proceeded to direct the jurisdictional inspector of schools to hold the charge of the said post. Subpara. The petitioner, being aggrieved by the said order dated 10/4/2023, approached this court by instituting WPC number 3152/2023, wherein this court, while order dated 6/10/2023, after noticing the claims made by the petitioner, disposed of the said petition, directing the Director of Secondary Education Assam to consider the claim of the petitioner and consider the claim of the petitioner and pass appropriate orders thereon. Full stop. The Director of Secondary Education Assam, in terms of the directions passed by this court, while the said order dated 6/10/2023, proceeded to issue the order dated 1/11/2023, and therein, by assigning reasons, proceeded to reject the claim of the petitioner for being allowed to hold the charge of the post of principal of the said school. Full stop. Being aggrieved, the petitioner has approached this court by way of instituting the present proceedings. Also, Mr. Purkhainsta, learned counsel for the petitioner, by referring to the seniority list dated 27/22 as available in the as brought on record in the writ petition, has contended that after Siddiq Ali Ahmed, he is the only eligible teacher having the requisite educational qualifications for being appointed as the for being appointed as the regular principal of the said school, and accordingly, a vacancy having arisen in the post of principal, he should be permitted to hold the charge thereof. Also, Mr. Purkaisto has submitted that the Director of Secondary Education, while the said order dated 1/11/2023 had not considered the matter in its proper perspective, and accordingly, the said order requires an interference from this court. Per contra, Mr. U. Sharma, learned counsel, appearing for the state respondents, appearing for the department. Standing counsel so and so appearing for the department by placing reliance on the instructions as received by him in the matter, has submitted that the post of principal in the said school having not been so created till date, the right of the petitioner to hold the charge thereof cannot be determined by this court at this juncture. Full stop. It was further submitted that the petitioner, although petitioner did not possess the requisite teaching experience mandated, prescribed under the rules of 2018 for appointment as the for appointment against the post of principal, and accordingly he would not be entitled to hold the charge of the said post. Full stop. It was further full stop. Mr. U. Sharma has further, basing on the said instructions, raised a dispute with regard to the date on which the petitioner herein was authorized the graduate scale of pay. Full stop. Accordingly, basing on the said submissions, Mr. Sharma has submitted, basing on the said premises, has submitted that the claim of the petitioner for holding the charge of the petition of the post of principal of the said school cannot be ought not to be granted by this court, ought not to be allowed by this court. Full stop. I've heard the learned counsel for the parties and also peruse the materials available on record. Full stop. The petitioner herein claims that he is a graduate teacher. He is working as a graduate teacher since the time when when he was under the elementary education department, and accordingly contends that as his seniority in the school as a graduate teacher has to be reckoned with effect from 2011. Full stop. Mr. Purkaisto had relied on the seniority list brought on record dated 27/22, brought on record in the petition to contend that he was the only teacher having the requisite educational qualification for holding the charge of principal after the retirement of Siddiq Ali Ahmed. So a perusal of the said seniority list would go to reveal that therein the date of receipt of graduate scale of pay by the petitioner has been denoted to be apostrophe 4/8/2016. So the above being the position, the relevant rules holding the field is now required to be examined. So the manner and method in which the post of principal is the recruitment to the post of principal is to be undertaken is provided for under the provisions of Rule 12 of the Assam Secondary Education bracketed Provincialized School bracket over the Rules 2018, and therein under Rule 12 Rule 12 bracketed 3 lays down the minimum qualifications for appointment to the said post in a higher secondary school. So the said same being relevant is extracted here in below. Rule 3/12(3) pura. A perusal of the said rules goes to show that the candidate for recruitment to the post of principal in a higher secondary school must have a master's degree along with a BT/B.Ed degree. Further, a graduate teacher is required to have a minimum of 17 years of teaching experience as a graduate teacher in any higher secondary school for being eligible to be considered for appointment as principal of a higher secondary school. So the above being the position emanating from the said rules, this court would now like to rely upon a decision of this court in the case of Jagannath Pegu versus State of Assam and others, reported in 2007, 3 GLP 389. The relevant conclusions as drawn therein is extracted herein below. Ikni reading. So, having noticed the provisions of the rules as well as the conclusions reached by this court in the case of Jagannath Pegu, Supra, this court would now examine the reasoning as contained in the order dated 1/11/2023. On perusal of the said order dated 1/11/2023, it is seen that the claim of the petitioner was rejected on 2 counts. So, the first count on which the petitioner's case claim for holding the charge of principal was rejected was that the petitioner herein did not have the mandated 17 years of teaching experience as a graduate teacher in a higher secondary school. Also, they said reasoning on being examined in the light of the materials available on record with regard pertaining to the service of the petitioner, as well as the provisions of the rules, it is seen that the said reasoning is so made basing on the provisions of the rule holding the field, and accordingly the same would not call for any interference. Also, it is to be noted that even if the claim of the petitioner that he is serving as a graduate teacher since 2011 is taken on the face value, still the petitioner would not complete the petitioner has not acquired the 17 years teaching experience so mandated under the provisions of the said rules. So this brings the court to consider the second issue as second ground as assigned in the said order dated 1/11/2023 for rejecting the claim of the petitioner herein. So the MA degree as obtained as acquired by the petitioner from Krishnakanta Hendrick Open University was held to be not valid in as much as the same was so pursued by the petitioner without taking due permission from the departmental authorities. Also, the said issue has already been dealt with by this court in the case of Thaneshwar Nath, and this court has held that merely for not taking a prior permission, the degree so obtained by the petitioner cannot be held to be invalid, and the provisions of section rule 13 of the what they have gone for the Assam Discipline and Appeal Rules, Assam Services Conduct Rules 1965 is not violated, is not violated. Full stop. 64 is not violated. Zero silent. Full stop. Having concluded as above with regard to the order dated 1/11/2023, this court is of the considered view that the second ground as assigned in the said order dated 1/11/2023 cannot be sustained, and the same is interfered with, and the MA degree as obtained by the petitioner is held to be valid. So, however, the petitioner herein not having acquired the requisite teaching experience, the first ground as assigned in the said order is not interfered with, and accordingly, subject to the findings herein above with regard to the second grounds, that is the MA degree of the petitioner, the order dated 1/11/2023 stands affirmed. So, it is seen that the petitioner hearing is functioning as the was permitted to look after the academic affairs of the said school, wide an order dated 2/9/2023 issued by the jurisdictional inspector of schools, and accordingly, the same is not interfered with. So, in view of the above conclusions, the order dated 1/11/2023 is upheld, and accordingly, the writ petition is held to be, the writ petition stands dismissed, subject to the conclusions as recorded herein above with regard to the MA degree as possessed, as acquired by the petitioner from KK Open University. Also, with the above observations and directions, the writ petition stands disposed of. You will get the order 2-3 days.
Another, I have, in case, Pulendo Kolita, my lord. In this order was not again provided because the order, some correction in the required with regard to date of the order, my lord. That is why we can.
Pulendra Kolita, you give the number.
1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1 1
Yeah.
Deeply obliged. Lordship, my senior Mr. P. Nair for PWD. He's on legs in court one. Matter must be
Okay, let him be. Yes, madam.
Lordship,
We have found the answer. We have found the answer. The reasoning is, have you got the orders from Mr. B. Chakraborty? Okay, forget it. You come to page 39,
page 39 of my petition.
a writ petition. This is your junior, Sanjeev Datta, right? Now, why that difference? You come to clause 11 of that. Advance increments as weightage of past service under Rule 9(1)(c)(1), 9 years above. So, he was stagnating there. So, he was given this advance increment. Now, you come to the office memorandum, page 55. Come to 2 subclause 1. When the pay of the junior is fixed with benefit of advance increment, sanctioned under so and so, no equalization, you come to that paragraph above, so and so is admissible. So in that view of the matter, how can we proceed to grant you any relief here? Have you got it? We have got the answer, Mr. He was given advance increments.
Lordship, on 20, this part, Lordship, I received some instruction. And as per my instruction, Lordship, Finance Department has given approval to the proposal submitted by the PWD.
Okay. You are approving it. Fine. Give it
Has
to
already
me.
approved, Lordship.
Give it to me. You are saved. You are saved. So you are allowing it.
Yes. At least Finance Department has given approval. Lordship, in fact, the other person who was given 3 weightage, Lordship. That
You
is why
cannot.
his.
Because of that weightage, your office memorandum says that under such circumstances, stepping up will not take. Now that you have given an approval, I'll not go, I'll just quote this and I will allow the repetition. But
That
Ms.
is the
J. Bezboru, Allah counsel for the petition. I will not write a long order, I will write a short order. Also, the petitioner in the present proceedings has raised a grievance with regard to the inaction on the part of the respondent authorities in not stepping up her pay with effect from October 1998 to the stage of pay as drawn by her junior, that is the respondent number 8 herein. Also, the petitioner has contended that although both the petitioner and the respondent number 8 were initially recruited as section assistants, it was the petitioner hearing who was senior to the respondent number 8 all along. So the petitioner was thereafter promoted to the post of
grade 2.
what are the posts?
Promoted to subordinate engineer, grade 2. I think.
Grade 2, and thereafter to the post of subordinate engineer grade 1. And in all these grades, it was the petitioner hearing who was senior to the respondent number 8. Also, accordingly, it is submitted that the petitioner hearing was required to be the pay of the petitioner was required to be stepped up to the stage at which the pay was so fixed in respect of the respondent number 8 on his promotion to the post of subordinate engineer grade 2 as well as subordinate engineer grade 1. Full stop. Mr. Naik, learned counsel for the appearing for the finance department, has, by placing before this court the instructions so received by him, has contended that a proposal in this connection, proposal with regard to stepping up of the pay of the petitioner to that of the stage, that was being so drawn by the respondent number 8 hearing, on examination, on receipt was duly examined by the finance bracketed establishment -A department, and accordingly noticing that an anomaly had arisen in the matter, comma, the finance department wide an endorsement dated 9/1/2019 had granted had accorded its no objection to the proposal of stepping up of the pay of the petitioner sub-engineer grade 2 from 4390 to 4720 and to equalize the same with that of the respondent number 8 hearing. The above being the position, no further adjudication is called for, and accordingly, basing on the said endorsement dated 9/1/2009 as 19 as given by the finance department, comma, the pay of the petitioner is hereby directed to be stepped up to the stage as was drawn by the respondent number 8 on his promotion, and thereafter the and fixed at that stage, and thereafter the areas of pay now that would become due to the petitioner be so calculated and released to the petitioner at the earliest. Also, in view of the above, the respondents in the Public Works Department is directed to take note of the endorsement dated 9/1/2019 of the Finance Department, and thereafter on stepping up of the pay of the petitioner to release to him the arrears, so working out within a period of 6 months from the date of receipt of the certified copy of this order.
Just one object. Lordship, she is under Maibong Lordship, Limahasa Authority. Lordship.
Whoever it is,
So
PWD authority.
They will do the necessary Lordship, and if any approval is required, Lordship Department will give that.
Full stop.
Instead of PWD.
PWD
Limahasa.
लिखो सुना है? The PWD along with the authorities of the he is your employee.
No, PW employee law.
The money will be given by you only. The instructions as placed as produced furnished by Mr. Naik, Learned Standing Counsel Finance Department, is kept on record and marked as X.
Lordship, I
So,
am-
ma'am, you had a good day today.
Yes, Lordship. And
Very
Lordship,
stars are very bright.
Lordship, the Learned Counsel, Mr. DC Kadhajalka, Lordship, his name may be reflected in the.
We'll reflect your name.
No, Lordship.
We'll reflect your name.
Lordship,
You have won the case. No, I'm not. I'm against that. We'll reflect your name only. We have reflected.
Lordship, let me keep a photostat copy of the instruction.
Lordship, I am open
Applies.
for respondent number 3,
Miss
S. Barik.
S. Barik, Learned, ऊपर लिखी बोले. Learned Counsel appears for the respondent number 3. AG.
SK Medhi.
On behalf of Mr. S.K. Medhi, Learned Standing Counsel, AG. Okay, done. Yes, what have you decided? Settled.
Give a proposal, we have stepped down to 21 lakhs.
So you have settled down?
Provided that it should be one
No.
time payment.
No provision. You agree or we decide?
We agree.
And whether you are giving him one time,
Yes, Lordship.
one time,
Within 3 months.
within 3 months, okay. The present proceedings was instituted by the petitioner hearing, praying for a release of the amounts awarded to him by the MACT Kamrup in MAC case number 1309/2018. Also, it is to be noted that the amount awarded to the petitioner were being so released to him by the ASTC authorities in monthly installments of rupees 50,000.
Yes.
Also, however, on the last date of listing, the learned counsel for the parties had submitted that a out-of-court settlement is being tried by and between the parties and accordingly had prayed for an adjournment in the matter. Full stop, subpara. Today, the learned counsel appearing for the petitioner as well as the ASTC authorities have submitted that they have agreed to that on discussions, the petitioner has agreed to scale down the amount receivable by her, inclusive of interest.
Yes. All.
Yes.
All.
Inclusive of interest.
Yes.
Inclusive of interest to rupees 21
Lakhs.
21 lakhs bracket or liquidivo. So the learned counsel appearing for the ASTC submits that in terms of the said proposal, which the proposal of the petitioner for receiving an amount of rupees 21 lakhs was accepted by the ASTC authorities and the payment thereof would be made within a period of 3 months from today.
Yes.
Today, full stop. In view of the said agreement as arrived at between the parties, this petition is disposed of, directing the ASTC authorities to release to the petitioner the amount of rupees 21 lakhs against the awarded, being the settled amount arrived at by and between the parties against the award in question within a period of 3 months from today. Also, failure to release the said amount within this set period. Now, again, agreement. With the above observations and directions, the petition stands disposed of.
Lordship, I am for respondent number 2.
Ms. M. Bora, learned standing counsel, Transport Department, appears for the respond number 2. Okay. Deputy Commissioner, Ms. A. Talukdar, learned government advocate, appears for the respond number 4.
Keep your.
Item 4.
May please your lordship. Lordship, today morning I have checked the record, lordship, and I found that respondents have entered appearance today for the first time and they have filed an affidavit in opposition. But copy we have not received, lordship.
Get the copy. Forget the affidavit. You satisfy me from the award.
Lordship,
2 o'clock. If you're having problem, 2 o'clock. But today we are disposing this.
tomorrow, lordship, at least tomorrow we'll have to go.
2 o'clock, 2 o'clock. Forget the affidavit. I'll not even go into the affidavit. Because they have said nothing new there. What is there in the award that has been reversed. You make out your case. And Mr. Hussain, show me there was a post. There was a post available. Because if your case is that the other person, some Mushahari, a Rabha, was promoted against a post which you ought to have been promoted.
Right.
If that be the case, that promotion should be interfered with. Otherwise, there will be no vacancy. How can you, without that promotion being set aside,
No.
1.
Right.
2, your case is that the railways ought to have acted in the matter 10%, 5% increase in the rules. Railways did not act.
Right.
Now today, can we tell that you should have done this, you have not done that? So give him promotion.
No,
There are latest decisions of the Supreme Court on that. Like
the vacancy arises after the retirement S.N. Das.
S.N. Das vacancy was utilized for Rabha. Both together, an amalgamated seniority list was prepared.
That is not Turner trade and mechanic. That is against the rules.
We will not go into that today because those issues are not under challenge. Rabha is not under challenge. Rabha's promotion is not under challenge.
No, it is a reference case. That
Be that as it may, we'll have to see because if we pass an order today, that will have an adverse consequence on Mr. Rabha. Without removing him, I can't bring you in because there is no post.
The post is again S.N. Das.
S.N. Das post,
For the
Rabha
purpose
is
of-
already promoted.
That is why for the that
MCA. master turn. And there are materials.
That amalgamation.
Sorry, the award cannot be sustained. But she will have to make out her case. 2 o'clock. 2 o'clock. You find out the
Yeah.
way out for me to be with you.
Lordship, can it be on tomorrow, Lordship?
All hard work will go down the drain. Again, I'll have to pay.
My lord.
Okay. Yeah, Kali. Tomorrow.
March over.
Item 5.
Yes, madam. What is left? What should I extend? Which is not even there existing.
But they could not have removed me, Lordship.
That removal is gone. That was in your earlier proceedings. That was in your earlier proceedings. By the time you came here, the period of your contractual engagement had already expired.
So there was a writ petition pending along with this attack.
Be that as it may, there was no stay. They had worked on it. Intelligent people. They did what is to be done. After 2016, you don't have an agreement. Now, in absence of that agreement expired in 2016.
No, but he's a contractual employee.
That's
He
it.
cannot be another set of contractual.
Forget it.
employees.
There are Supreme Court decisions, Gridco onwards, serially.
It's the same project, same work.
And that advertisement, you also had participated.
That is because it is abundant caution, Lordship.
I don't think so.
There is on the last occasion, there was an order by this honorable court, and there's a vacant post still, it is being there.
That is, you appear in the, we will direct them to consider your case in that selection on merits. Sorry, before a wrong court.
No, not Lordship. No, but Lordship, the law is clear.
Law is very clear. If you want to make it more clearer, I can make it more clearer.
Lordship.
That I will extend something which is alive, which is lost its force, section 14, specific relief act. For damages, you will have to go before the civil court. In that view of the matter, how can I help you here? You have something more?
My
Bring it.
prayer, Lordship, remains the same.
Your prayer remains the same, but your circumstances have changed with that order dated 22/5/2017.
That is why I'm here before this.
Even if I set aside this order, I can't revive your engagement. I can't direct them to engage you. I can't. Supreme Court is very clear on that. Gridco and other cases.
For that bad order, Lordship, that impugn order, I would have still remained in service.
You would have, that was the case in the earlier round of litigation. But you have withdrawn that.
No, that they have said that's
Madam, you have withdrawn that. Then they issued an advertisement.
withdrawn, Lordship.
No, that was become infructuous.
No, Lordship.
That was, yes, you have made a statement. You have made a statement in paragraph 8. Whatever, that writ petition is still pending.
No, it is not pending.
It
Because
was,
since I came with this petition, the honorable court for the right to close that petition.
can't help it. Fate. But this I cannot. I'm sorry.
It's okay, Lordship.
This I cannot. Because Gridco and,
My submission will be, Lordship.
but I can do one thing for you. I can, because they have stalled this process of recruitment. They have filed an affidavit saying, I'll direct them that your case therein shall be considered on merits, not being influenced by anything else. That much I can do. Think over it. Come back after some time. Whenever you are ready with me.
Lordship, it's okay. Lordship,
No,
it's fine.
you think over it.
No,
Come
my
back.
only contention was, Lordship, they had passed a punitive order. against
Madam,
me.
they have passed a punitive order. They have rectified that. 22/5/2017. Thereafter, 16 onwards, you are not in service. They have paid you.
But Lordship, subsisting that writ petition, I was with the same, this writ petition was,
But there was no stay order in that writ petition against the order of termination.
but here it was.
Here, only the advertisement was stayed subsequently.
Lordship.
So they have also stalled that. It's neither helping you nor anybody because that organization, a post of accounts officer is lying vacant. So we will now dispose of this writ petition, directing you, your case, to be considered on merits without being influenced by anything. That much I can do.
I'll pray, Lordship, that observation, Lordship, that punitive. But I know it is, once it is withdrawn, it is gone.
Gone.
Yes.
We will say, because of that, I will say that you having withdrawn it, anything that was there, that shall not be held against the petition, and his case will be considered on merits. This much I can do. Pass a short order then. But yes, MS SP Hussain, Learned Counsel for the petitioner. None has appeared for the respondents. So, the petitioner, by way of instituting the present proceedings, has presented a challenge to an order dated 22/5/2017, which has the effect of discontinuing her contractual engagement in the Assam Urban Infrastructure Investment Program, hereinafter referred to as the AUIIP. So, the facts as requisite to be noticed for adjudication of the issue arising in the present proceeding is noticed as under. Also, the petitioner hearing on execution of the agreement dated 19/12/2014, right?
Right, Lordship.
Was engaged on contractual basis as an accounts officer in the office of the project management unit of the AUIIP. So the petitioner on being so engaged. So they said engagement of the petitioner was for a period of 11 months. So on conclusion of the set period of before conclusion of the set period of contractual engagement, it is contended that the services of the petitioner therein was extended, and the same stood so extended till 19/12/2016. Also, while the petitioner was so serving during his second term of contractual engagement, his services came to be terminated while issuance of an order dated 23/11/2016. Being aggrieved, the petitioner had approached this court by way of instituting a writ petition being WPC number 2494 of 2017. So, while the said writ petition was so pending, the respondent authorities, while an order dated 22/5/2017, proceeded to recall the order of termination of the petitioner dated 23/11/2016 and further release to him his remuneration till the completion of the extended period of contract, that is till 19/12/2016. Full stop. It is to be noted at this stage that the services of the petitioner was not continued after to 19/12/2016 by way of execution of a fresh contract agreement. Also, thus, the respondent authorities proceeded to issue an advertisement dated 4/4/2017, and therein also put up the post of accounts officer hitherto before held by the petitioner, for a recruitment. It is contended that the petitioner, as a measure of abundant caution, had also applied against the said advertisement. Also, thereafter, the petitioner approached this court by way of instituting the present proceedings, presenting a challenge to the order dated 22/5/2017. Also, the Learned Counsel for the petitioner has contended that the order dated 22/5/2017 requires to be interfered with, and requires to be interfered with by this court with further direction to the respondent authorities to continue the petitioner in her services, in as much as the recruitment process as instituted would have the effect of replacing one ad hoc with another. Also, I have considered the submissions made by the petitioner hearing. What is to be noted here is that the petitioner was so engaged in the organization on contractual basis, and the said contractual engagement having come to an end on 19/12/2016, there was no further extension thereof by way of either an order of extension and or by way of execution of a fresh agreement. Also, the services of the petitioner having not been so extended, comma, this court would not be in a position to direct the respondent authorities to again engage the petitioner on contractual basis. And in this connection, this court would draw support from the decisions of the Supreme Court in the case of Gridco and I'm going to read case of 2011, 15 SSC, 16 Likitvedia, para 38, 39 to court Koediba, and also the decision of the Supreme Court in 2011, 15 SSC 180. Also, Baki Ekini, Kitapini 9, Kitapini second. In view of the above position, there being the petitioner having approached this court after expiry of the period of contract, comma, any grievance with regard to such non-extension would not be maintainable in a writ proceeding, and the petitioner has to approach the civil court of competent jurisdiction for claiming damages. Also, however, noticing the fact that the advertisement in question, that in pursuance to the advertisement in question, the petitioner had also participated, and in pursuance to the interim directions passed by this court in the present proceedings, the recruitment process as initiated while the said advertisement was kept in advance, comma, this court requires the respondent authorities to now proceed with the process of recruitment and therein to consider the case of the petitioner on merits. Also, it is to be noted that although the petitioner was terminated from her contractual agreements basing on certain allegations so leveled against him, but the withdrawal of the termination order dated 22/5/2017, the said allegations be not now held against the petitioner and his case be so considered strictly on merits in the selection process as initiated by the advertisement in question. With the above observations and directions, the writ petition stands disposed of. Can't help it.
It's okay, Lordship. Obliged, Lordship.
Item 6,
Samat, Sumed, and any other name? Huh? Your school certificate is Sumed and your appointment is Samat, and you have not made a statement in the writ petition saying that these both are same. How do we proceed with 3 dates of birth?
In fact, Lordship, now the case is that
Where is that 22 letter you had produced?
there was a order.
22.
As per my instruction, Lordship, the petitioner has signed an affidavit, Lordship, and then he stated that he is not interested to proceed with the matter, Lordship.
Yes, Mr. What is this? Before the deputy superintending engineer has brought on record an affidavit by you, wherein he has said that he is not proceeding with the matter.
That I could not contact the.
Forget it. We'll record this because it has been produced by the authorities. So, in terms of the, because of some letter 2322, yes, 2322.
My lord, even
This was given to you on the last occasion.
yes, my lord, but I could not contact the, my lord, the
Forget it.
petitioner, my lord.
Forget it.
Person number.
full stop. On 11/3/2022, when this matter was taken up for consideration, Mr. Upadhyay, Lanark Council appearing for the irrigation department had produced a communication dated 3/2/2022, wherein the petitioner was stated to have admitted the date of birth as now reckoned by the respondent authorities for the purpose of determining his date of superannuation. Today, Ms. A. Talukdar, Lanark Junior Government Advocate, has placed on record a communication dated 21/3/2022 received from the Additional Deputy Commissioner, Dorong, wherein a communication dated 3/3/22 of the Superintending Engineer, Mongoldoy Circle Irrigation, Mongoldoy, has been enclosed, wherein it was stated that the petitioner herein had filed an affidavit to the effect that he would not further pursue with the present proceedings and that he has accepted the date of his superannuation, that is 31/12/2018. So they said material being brought on record by the respondent authorities and not being disputed by the petitioner hearing, basing on the said premises, this writ petition is closed on account of non-prosecution of the same by the petitioner hearing. So accordingly, the writ petition stands dismissed for non-prosecution. A copy of the communication dated 21/3/22 as furnished by Ms. A. Talukdar is kept on record and marked as X for indication.
All right, Lordship. Respond number 2. Our name may be recorded.
Huh?
Our names may be recorded.
You are for?
Respond number 2.
Mr. P. Nayak, Lanark Council is present for the respond number 2. Yeah, item number. What is the latest notification with regard to recruitment of Gaumburas?
30 years.
410,
410
new notification, 2018, 10/4 to 2018. The
10
new notification,
10/4/2018.
18.
And therein it is 35 years.
Yes, 35. And this, the advertisement was after that notification. It means there is no ground for the petitioner that.
Wait.
Yes,
The latest notification is of 2021, my lord.
Why are you so harsh on him? Yes, come up, let's see. Okay, this is the one that is holding the field,
Lordship.
right? And Mr. Rafiq, in the present proceedings, so yeah, in the present proceedings, you have not challenged this 410.
Yes,
That is not. Advertisement was, my lord, 35 years.
And 35 is according to the, what is the date of the advertisement?
Date of the advertisement is, my lord, 7/6/2018.
2018.
yes,
So if it is 7/6, that is, it is after 10/4.
Yes.
So 10/4 notification is not under challenge.
But presently, my lord, the notification holding the field is, my lord, 30 years is the upper is minimum age criteria, my lord. The present notification was still fine. 30 years, my lord. Instead of 35 years, they have amended the.
Now it is Gaon Pradhan.
yes.
After
Gaon
Gaon Pradhan
Yes.
designation, is there any new procedure for recruitment?
Yes, my lord.
Of course.
In 2023, my lord, there is an advertisement.
Okay. We will hold that your writ petition is not maintainable because you have not challenged the order notification dated 10/4/2018.
Right.
But we will say because of the passage of time, new persons have become eligible. So we will interfere with the advertisement and require them to publish the advertisement in accordance with the norms holding the field today.
My lord. That will do.
Will do?
Now, my lord, it is reduced to 30 years.
30 years.
No, that notification also I.
Advertisement was stayed by this rule court, my lord. The advertisement under challenge, my lord, because stayed, my lord.
My lord,
Those people are gone. So today, if we even revive that, nothing will happen because you are also not there. Nobody is there.
I'm not. It was my lord state till returnable there. On the-
After that, there is no
That-
extension.
there is no
After that, but you also did not proceed with that. With the advertisement, did you proceed with the advertisement? No. Then you had too much of respect for this court. So you did not. Good. Right. Heard Mr. Ayat Soikia, learned counsel for the petitioner. Also heard Mr. J.K. Goswami, learned. You are Mr. Goswami, additional additional advocate general.
No.
Additional senior government advocate appearing for the respondent number 2 and 3. Also heard Mr. J. Handick, learned standing counsel revenue and disaster management appearing for the respondent number 1. The challenge in the present proceedings is to an advertisement dated 7/6/2018 issued by the Deputy Commissioner Barpeta inviting applications for filling up the post of Gaon Bura of Bagbhar Mauza under Bagbhar Revenue Circle. The grievance of the petitioner is that in the said advertisement, the minimum age requisite for a candidate to apply for against the said post has been fixed as 35 years or above as on 1/1/2018. So today, when the matter was taken up for consideration, Mr. Handick and Mr. Goswami have placed on record a notification dated 10/4/2018 by which the executive instructions holding the field under the governing executive instructions governing the manner of recruitment to the post of Gaon Bura under the Assam Land Revenue Regulation, 1886 was amended, and therein the minimum age was so prescribed as 35 years for an applicant to apply against the said post. So, the advertisement having been so issued in terms of the notification dated 10/4/2018, and the provisions of the notification dated 10/4/2018 not being under challenge, the petitioner herein cannot, in absence of a challenge to the executive instructions as brought into force by the notification dated 10/4/2018, present a challenge to the above noted writ petition, and accordingly, it is held that the writ petition, that the challenge to the said advertisement by the petitioner herein cannot be sustained. Also, however, Mr. Soikia, learned counsel appearing for the petitioner, has brought on record a notification dated. It has come down to 25 now. No,
30.
30. No, there is a notification of 27/10/22.
My lord, there is some typographical error, lordship.
Okay, we'll say it's 35.
30. Now, my lord,
30,
19/7/2000.
sorry. Has placed on record notification dated 26/8/2021 by which the executive instructions governing the process, governing the recruitment to the post of Gaon Bura was further amended, and the minimum age of 35 years as prescribed was changed to 30 years, and accordingly it is contended that as on date, for the purpose of recruitment to the post of Gaon Bura, an applicant has to be 30 years or more on the date, so on the last date of the advertisement, for being eligible to apply again, for being eligible to be considered for appointment against the post of Gaon Bura. The above being the position, and the advertisement dated 7/6/2018 being stalled by interim orders passed, having not been taken forward on account of interim orders passed in the present proceedings, this court is of the view that the said advertisement dated 7/6/2018, also in view of the lapse of time occasioning since its issuance and more eligible candidates have, and more candidates having become eligible in the meantime, the said advertisement dated 7/6/2018 requires to be interfered with. So accordingly, the advertisement dated 7/6/2018 is set aside. So having interfered with the said advertisement dated 7/6/2018, the respondent authorities, more particularly the Deputy Commissioner Barpeta, is now required to re-advertise the post of Gaambura of 30 number charge under Bagbar Moza with Bagbar Moja strictly in accordance with the executive instructions holding the field governing the recruitment to the post of Gaambura as on date. Also, the said advertisement be so issued within a period outer limit of 3 months. 3 months from the date of receipt of a certified copy of this order. With the above observations and directions, the writ petition stands disposed of.
Lordship, complete the whole process. Advertisement is okay, Lordship, complete the whole process. Kindly extend some time.
3 months. For
5 months.
advertisement only, I said 3 months.
5
Thereafter, you file, you do it. I have not said how much time you should be.
Lordship.
Or you want me to put out to you?
No.
And these two I am keeping. You're not getting it back.
That's.
Item 8.
Wait, please, Your Lordship.
Yes,
I will be allowed to file our reply,
No.
my lordship.
I'm allowing your writ petition.
My lord,
I'm allowing your writ petition. Now you want to file a reply?
No, my lord.
Now you file a reply. Yes, Miss.
my
Then,
lord,
what
here-
is this?
Here main issue is above 50 years of age.
See, your regulation says you can recruit a person from 18 to 50.
Yes,
Whether he'll be continued after 50 is subject to verification of his.
yes, that is the,
So why?
yes, ma'am, kindly see that, that is.
You're that
amendment
sub-
of-
You're that officer commanding, he went overboard, saying that anybody above 50 should not be. Do you think people above 50 can't work? Yes, Ms. Gayan.
kindly
Do you
see
think, no,
that-
no.
kindly
Do you
see-
think people above 50 can't work? Then we should
Yes.
be also out.
Yes.
Then?
For that, madam, kindly see the earlier parties, madam, page number 1, madam. For the personnel above the age of 18 but below the age of 50 years may be employed on the daily. That is earlier. That was amended and madam, now this is read as second page, madam. The personnel above the
Ah,
age 18
this
years
is
may be
what is
employed in
required.
the BOR subject to the physical fitness, madam. That yes,
So in this
on
view of the
basis
matter,
of
give her a copy.
yes, ma'am.
Give her a copy. Madam, you just go through it. If that is done, we need not pass a long order. Just go through that. We'll take it up after some time. When you are ready, just inform me.
Yes.
Madam, when you are ready, Ms. Bhuyan. When you are ready, just inform me. Petitioner lost interest.
Similar set of writ petition is also.
I have
pending.
already answered one now. Similar orders have been passed by this court. Same order that I passed a little bit before.
They have challenged the
Notification.
advertisement, lordship.
And their challenge is only on that count that 35 years.
Yes, lordship.
Now it is 30 years.
It's 30 years.
So their challenge is only to that extent.
They want this because they challenged because earlier it was 40 years, lordship. Pre 2018, lordship.
So now it is 30 years
Yes, lordship.
and these people were just 32.
And they have not taken any steps also for getting
I know.
instruction and all these.
None
lordship.
appears for the petition on call. Nothing is there.
Yes, lordship.
The writ petition. Heard Miss Miss M. Bhattaji, learned counsel for the learned additional advocate, government advocate, appearing for the state respondent, and Mr. J. Handick, learned standing counsel, Department of Revenue and Disaster Management is present. Full stop. Accordingly, the writ petition stands dismissed for non-prosecution. Interim orders passed, if any, shall stand vacated.
Obliged.
Lord, in this case, Lord, I have an instruction to withdraw this certificate. So I shall file a formal application. Some days later.
Because they are not employees. They have taken a very valid ground. So they can come, the persons can come.
No, so I shall file an application tomorrow.
No, for that, you need not have any liberty because it will be,
be.
it will now be by, this is by improper persons, now it will be by proper persons. We'll withdraw it. You want to withdraw it?
Yes, not today, because formal application will be filed.
Formal application for what?
Because this is a petition filed by the union.
So I'll dismiss it. I'll dismiss it. That they don't have any locus.
No, I have an instruction.
Then withdraw it. I will not continue with this. That if your oral thing is enough for me. Your oral submission is enough for me. Can give me.
Because the lead will file, it's so required.
You can file a writ because that will not be a bar because we'll hold because this petition has been filed without locus. So now when the proper persons come up, this will not act as a res judicator. This cannot act as a res judicator. Right? So we will close it. You take steps.
The lead to file is so.
No need. No leave is required. Okay, I'll put it.
Because I have the.
I'm putting it. Mr. D. Dasgupta, Mr. A. Dasgupta, Lanat's counsel appearing for the petition and also Mr. We'll record your name.
This instruction may kindly be kept in the record.
Chaudhary, D. Chaudhary, Lanat counsel appearing for the respondent bank. Also, the respondent bank, by way of filing an affidavit, had raised a preliminary objection to the effect that the Employees Association as petitioner had instituted the present proceedings in respect of 8 or 9 drivers, 8 numbers of temporary drivers engaged in the bank.
Those are not employees of our bank.
No, engaged in the bank.
Not engaged by the bank also.
Then whom?
Oh, no, this is the instruction.
Then whom?
Engaged. A allowance has been paid to certain officers.
Okay.
So
Okay,
those
okay, okay.
officers engaged them. Bank at any point
Okay.
of time.
Okay. The
No, this is the instruction.
has raised a preliminary objection. In respect of 8 numbers of drivers, which the bank contents were never recruited by them, even on casual and or ad hoc basis. Also, it is contended by the Lanat counsel appearing for the Mr. D. Chaudhary, Lanat counsel appearing for the bank, that the said drivers were so engaged in their person by certain officers in their personal capacity for the works involved. Full stop. Thus, Mr. A. Dasgupta submits that the present writ petition be permitted to be withdrawn and liberty be granted to the concerned drivers to approach this court if the occasion so necessitates. Full stop. The present full stop. Having considered the above submissions, it is noted that the Employees Association has instituted the present proceedings without any locus, inasmuch as the persons on whose behalf the present writ petition were so instituted were not employees of the respondent bank and accordingly cannot be treated to be members of the petitioner association. So accordingly, in view of the above position, the prayer of the petitioner is accepted and the present writ petition stands dismissed on withdrawal. You can come back because I've already noted.
That much of that.
That much I've provided. Achha.
Time being 8.
Yes, madam. I don't have the order, madam.
That'll do.
Well, that should be the subject to the physical fitness now. Yes.
So, heard Miss B. Bhina, learned counsel appearing for the petition, and also Miss A. Gayan, learned CGC appearing for the respondents. The grievance in the present, the challenge in the present proceedings is to, what do you called it? Page 18? To,
That is signal, Malad.
to a
Message.
oblique message dated 14/8/2017, issued by the Border Roads DTG, and directing therein that the casual workers in the organization can be recruited within the age limit of 18 years and 50 years. Also, consequent to the said signal dated 14/8/2017, where is that order of the commandant?
Page 68.
Page 67, proceeded to issue the commandant HQ9 Road Construction Company bracketed GREF issued a communication dated 7/8/2018, holding therein that the directing therein to remove oblique discharge all casual workers whose age are below 18 years and above 15 years and engaged in the works of the said organization. Also, today, when the matter was taken up, Ms. A. Gayan, learned CGC appearing for the respondents, have placed on record a communication dated 11/10/2018, and therein, under 18, pertaining to general guidelines for recruitment of casual paid laborers in the organization. Also, and therein, the earlier stipulation that personnel above 18 years but below 50 years may be employed on daily or monthly rates of pay on required basis, as was holding the field, was substituted with the following prescription, page 2A to A. Also, the present prescription as brought into force widely said communication dated 11/10/2018 pertaining to the engagement of the casual paid laborers in the organization, it is seen that persons above the age of 18 may be employed, and the earlier stipulation that such employment would be limited to persons aged aged 50 years has now been replaced with the stipulation that persons above age may be employed in the organization continuously, subject to their physical fitness and good health condition in order to perform the specified job. Also, in view of the said stipulation, the grievance raised by the petitioners in the present proceeding stands redressed. Also, it is provided that the casual paid labor be continued to be engaged after continue to be engaged with from the minimum age of 50 and even after 50 years if they are on examination found to be physically fit to take the work or to undertake the jobs for which they are so engaged. Also, with the above clarification, the present petition stands disposed of. A copy of the communication dated 11/10/2018 as punished by Ms. A. Gayan CGC is kept on record and marked as X for the purpose of identification.
Obliged, Lord.
Item 12,
मतलब some CPF dues are there. मतलब out of 15 lakh and odd, my lord, we have already paid.
No, Mr. That only grievance of Mr. Ahmed in the present proceedings now would be that interest that you calculated, interest portion, you calculated till 2008. You should have calculated because that money you had not deposited. So it was not taken into account. So that money ought to have been deposited and the interest till the date of his retirement and or till the date it was released to him ought to have been done. That much only is required here. And that you are bound to do because you are admitted that it was not paid.
We require time, my lord, because we have already paid around 12 lakhs.
We are only on that period. 1/4, what is that period, Mr. 1/4, 2003 to
31/8/2008.
1/4,
2003 to 31/8/2008.
01/04/2003 to
31/8/2008.
so this money has been deposited now,
Deposit.
but the consequential interest was only calculated till 31/8/2008.
No, money not deposit. Money is also being held up. Only calculations were done.
Okay, and the calculation is till 31/8/2008.
That they have rectified now.
Hmm.
They have recalculated it. But
Till
the amount has not been released
recalculated till when?
till the date of retirement.
Okay, fine. We'll direct them to release that amount within a stipulated time.
Well, some time will be required. now.
Yes, we'll give you, Mr. We understand your position. But a retired man's dues cannot be kept withheld like this. Or give him one of those green buses, 1 or 2 of those green buses. Let him operate. It will be around 12-15 lakhs, be more than that.
Then
Okay. You pay the rest amount. Do you take one?
No,
green
out of
bus?
15 lakh and odd, my lord, we have paid around 12 lakhs.
So, Mr. Ahmed, you are satisfied with this calculation?
yes, satisfied. For instruction receipt.
At page 20, my lord.
So, Mr.
My lord, page 20, that calculation is there, my lord.
No, he has given a fresh calculation here. Fresh calculation by your authorities. Wherein around 4, it works out to around 4,50,901 till the date of retirement. Right? So we will say you release this amount along with interest at bank notes from the date of retirement till the date of payment. Right? How much time?
6 months. my lord.
6 months. Also, as also heard Mr. Z.Z. Ahmed, learned counsel appearing for the petitioner, and also Mr. G.N. Sahewala, learned senior counsel, assisted by Mr. A.M. Sahewala, learned counsel appearing appearing for the Assam State Transport Corporation. Also, as agreed to by the parties, the present writ petition is being disposed of. Is being taken up for final consideration and disposal. Also, Mr. Z.Z. Ahmed at the outset has submitted that although the grievance raised in the petition pertains to the calculation of his PF dues, pertains to the action on the part of the respondent corporation in not depositing his PF dues along with the employer's contribution for the period with effect from 1/4/2003 to 31/8/2008 and thereafter calculating the said amount due to the petitioner along with interest only till it was calculated till August. Initially till August.
August.
August 2008, had instituted the present proceedings. However, during the pendency of the present proceedings, the corporations, the authorities of the respondent corporation have recalculated the said amount. So due to the petitioner along with applicable interest till the date of his retirement, and accordingly an amount of rupees and accordingly an amount of rupees 4,50,000, 901.74 was held to be due to the petitioner herein. Also, however, Mr. Amit submits that the said amount has also not been deposited in the account, in the EPF account of the petitioner till date. Mr. J.N. Savala on instructions has submitted that the amounts due to the petitioner shall be so released to him within a period of 6 months from today. Mr. Amit has accepted this said proposal. Full stop. In view of the same said submissions made on behalf of the learned counsel for the parties, the present writ petition is disposed of, directing the respondent corporation to release to the petitioner the amount as computed. That is, amount as computed towards his EPF dues, that is rupees 4,50,901.74, along with interest at the rate at the bank norms as applicable, with effect from 1/9/2008 till the date of its such full and final payment. Also, as undertaken, as submitted by Mr. Sahiwal, the said amount be released to the petitioner within a period of 6 months from today, along with the interest as mentioned here in above.
Much.
13.
How can I help you?
That's it.
How can I help you?
That's it. As per order dated 12/6/23, let's say.
Forget it. Forget it. Forget it. We'll go to the main issue. 3 posts were advertised. That is there in the minutes of the committee.
Right.
Once they got it, 3 posts were advertised. You are admittedly at serial number 4.
That's it.
Right?
But regarding the number of vacancies, let's say.
Forget it. Now we'll not go into that. Earlier, this court gave you a grace.
Let's.
And the deputy commissioner has passed a very categorical order. Now, your case will now boil down to the finding in that minutes that this list may be also utilized for future vacancies, which this court will not accept. So in that view of the matter, there is nothing. Anything more to say?
I'm leaving it here, let's say.
Why? I only cleared my mind. Now you argue. Dispel my notion. Yes, madam. Why?
Lordship, 3 posts were advertised and the petitioner, he appeared in the interview. His name is there in the 4th list. 3 persons have joined Lordship and this list was for 1
He is
year.
such a persistent man. He wants to work under you all only. See, where will you get an employee like this? So you should have accommodated him somewhere. Such a sincere man. See, from these elections are of 2005.
Yes, Lord.
Even 24, he is pursuing them. So on that basis, you should have given him something. So, madam, we'll dismiss it.
I understand.
Also, the petitioner has, by way of instituting the present proceeding, presented a challenge to an order dated 30/9/2018 issued by the Director, Social Welfare Assam, as it then was, rejecting the claim of the petitioner for appointment against the grade 4 post in pursuance to a recruitment process as undertaken in the matter. Also, the petitioner herein had participated in participated in a recruitment process held for the post of grade 4 as existing in the establishment of the district welfare, what do you call that? District,
Jorhat Lordship, Jorhat.
no, that what was the office? District Social Welfare Officer, Jorhat.
Jorhat.
So it is to be noted that 3 vacancies were so identified in grade 4 category in the said office, and the same was put up for recruitment. On conclusion of the process of recruitment, which were held at the district level, the director had constituted a committee at the state level for considering for considering the recommendations as made by the district level selection boards. So, on a due consideration of the matter, by applying the principle of 1:4, that is against 1 post selecting 4 persons, comma, a select list was so prepared and published by notification dated 11/11/2005, wherein against the category of grade 4 for the district of Jorhat, the name of the petitioner was placed at serial number 4 on merits. It is to be noted that 12 persons, roll numbers of 12 candidates were so reflected in the select list, which corresponds to the 1:4 ratio, and the fact that there were 3 posts put up for recruitment in grade 4 category in the establishment of the district social welfare officer. District, what do you call that? Social welfare officer. District Social Welfare Officer, Jorhat. So, the petitioner, not having been so appointed in terms of the set select list, he had approached this court by way of instituting WPC number 5090/2018. That is after around 13 years from the date when the process of said recruitment was so initiated. So this court, by order dated 3/8/2018, proceeded to dispose of the said writ petition, granting liberty to the petitioner to file a fresh representation before the state respondents within 10 days, and thereafter requiring the state respondents in their discretion to consider the case of the petitioner for appointment to a grade 4 vacant post. Accordingly, the petitioner, having submitted a representation, the Director Social Welfare Assam, wide order dated 30/9/2018, proceeded to consider the grievance of the petitioner, and thereafter, and on such consideration, proceeded to reject the claim of the petitioner for appointment against a grade 4 vacancy in the establishment of the district social welfare officer, Jorhat. Also, a perusal of the order dated 30/9/2018 would reveal that therein the director had noticed the fact that only 3 vacancies were notified for recruitment in Jorhat district under grade 4 category, and 3 candidates have already joined the said notified post. Accordingly, the claim of the petitioner was so rejected. In the present proceedings, the petitioner has not raised any dispute with regard to the placement on his placement on merits in the select list, and he has contended that his position is at serial number 4 therein on merits. Also, there being no post available for accommodating the petitioner in terms of his merit, in terms of the merit position as obtained by him in the said selection process, the rejection of the claim by the director, claim of the petitioner by the Director Social Welfare Assam, wide the order dated 30/9/2018, that would not call for any interference. Also, in view of the said conclusion drawn by this court, the present writ petition is held to be devoid of any merit, and accordingly, the same stands dismissed. However, there would be no order as to cause.
Oblige your lordship.
So, the present writ petition was so instituted by one Bina Burwa as petitioner. So, the order dated 19/2/2024 passed by this court in the present proceedings revealed that the petitioner hearing had expired on 7/10/2019. So, given the nature of dispute raised in the present proceedings, there being no other claimant to continue to pursue the present proceedings, the writ petition stands dismissed for non-prosecution.
Item 15.
Yes,
Yes, yes, Lordship, my lord.
yes, yes,
My lord, actually, I could not prepare the.
that I'll accept tomorrow.
Friday,
No, tomorrow.
Friday,
You prepared today, tomorrow.
tomorrow.
nothing
Yes,
is-
my lord, tomorrow.
You did not prepare, that's why I'm giving you a liberty.
But my
Tomorrow,
lord, yes, my lord.
tomorrow. Otherwise, I'm ready.
Oblige, my lord.
Item 18.
Please, your lordship, kindly matter may be fixed at two.
Yes,
May I please your lordship?
yes.
My lord, the petitioner and the respondent number 4 had solemnized minutes in 1998.
Talake Bayan,
My
show
lord.
me the validity. And also show me
My lord,
that this Talake Bayan in writing that was issued by you
my lord,
had reached the private respondent.
my lord, Talake ban has no validity, my lord.
Then you have
Some-
not divorced. So she continues
so,
to
my lord,
be,
So, my lord, divorce is the invalid divorce. So, my lord,
invalid, that is gone. So she
My-
continues to be your first wife.
Yes,
So she will be entitled to whatever benefits she is required to
No,
be
because
under
mine-
the service law.
because my name has been deleted from the service record, my lord.
Oh, sorry. Sorry. Yes, you are the petitioner. Yes. What is this? The divorce, show me. I was
Yes.
putting the question to the wrong person. You are the one.
Hello.
Yes,
Yes.
show me. Talake Bayan is a valid divorce. And if valid divorce, whether it has received by the petitioner.
Section 313 of the, my lord, the principle of Muhammad Allah.
Go to the latest Supreme Court judgments. Supreme Court has already held it to be invalid.
Yes, that is in
Triple
respect of
talaq.
triple talaq, my lord.
And Talake Bayan is a
Triple-
part of that.
My lord, I have gone through the judgment, my lord, in the.
Mr. Counsel,
Shairabanu
Mr. Counsel,
Judgment, my lord.
you tell me what is the validity of Talake Bayan and how a Talake Bayan is to be executed.
Yes, my lord. I am reading, my lord, the 313.
Forget 313. You tell me by your own experience. Tell me that.
Because, my lord, talaq in bayan, my lord, is a written. document.
Written.
Yes,
So
my lord.
today I issue a Talake Bayan
Yes.
and I just keep it in my drawer.
Yes.
I don't give it to my wife.
But, my
Well,
lord,
that would be valid.
I have stated, my lord, in my objection, my lord, it was handed over to the
Wife.
petitioner, my lord.
Okay.
Yes.
When was this Talake Bayan made?
My lord,
2018? 16, 18? Right?
my lord,
18. Okay?
2013.
13, sorry. 13. It's 13. Now,
2013.
from 2018 onwards,
Yes.
there are proceedings against you
Yes.
in different courts
My lord.
for maintenance.
Yes.
You have filed a criminal revision before this court also.
Yes.
It was only required because she had asked for an enhancement.
Yes.
Why was this factor not brought on record?
Because, my lord, even the divorcee also entitled maintenance, my lord. That is
I'm
why-
sorry, that was a vital statement you ought to have been made. Now you cannot take recourse to that.
And, my lord,
I'm sorry, we are allowing this repetition.
my lord, kindly come to the prayer of the writ petition, my lord.
Forget
Whether
the
the
prayer.
writ court has the
We
jurisdiction or not, my lord.
we will show how
Yes.
the jurisdiction is to be exercised.
Whether, my lord, page 18,
Yes,
prayer number 2, my lord.
page
A writ in
51.
the nature of mandam.
51. This they have done
Yes.
by
Yes.
taking the Talake Bayan on the
Yes.
face value. whereas it was never communicated or indicated in the proceedings. We will hold this order to be bad. Now I can do two things.
Yes.
You give her the benefits.
Yes.
Or I will make a declaration here that she continues to be the first wife. Under your service law, you having not taken a permission for the second marriage, your service will go. Which
Yes.
one do you opt for?
And my lord,
And I'll do it. Don't worry. Which one will you opt for? Give her the status of the first wife legally, or I will hold that marriage, that talak-e-bayan and all these things. I'll give my reasons. Don't are
yes.
honest. So, Mr. Counsel, what will happen is you will be saddled with two wives. And under your provisions of Act, it is a misconduct, 11 or 12. It's a misconduct. You can be dismissed.
my lord,
Decision is yours. Think over it. Come back after 15 minutes. Think over it.
my lord,
Talk to your client. Give her a status which she is entitled.
Yes.
Or this court will hold that the communication that was issued by the CRPF authorities, basing on your talak-e-bayan,
yes.
is honest. I will quash that. Further required, make a declaration that she is the first wife and you have married for the second time without permission. And I'll leave it at that.
My lord,
Miss, it will be communicated and you know the consequences.
then my lord, let the matter be remanded
2
to
o'clock.
the arbitrator, my
No,
lord.
no, no. 2 o'clock. 2 o'clock.
Because my lord,
2 o'clock.
they
2 o'clock. You think, you talk and
And
come back
well-
and tell me. I don't want to put you in trouble because you are also required to feed her and her child. So I'm not putting you into trouble, but I'm giving you an option. Think over it, come back at 2. Talk to your client also. Those things we will not permit. Right? 2 o'clock. 2 o'clock, Mr. Islam. Madam, 2 o'clock.
19 and 20.
highly obliged, your lordship.
My position also.
Hmm.
The finance department is supposed to place some instructions also regarding the regularization of service lordship. Kindly have a look, lordship, order dated 8/1.
The only regularization I can direct here was only that Upendas. That is also gone. How can your services be regularized even for a day? And if they want, Mister, you want to do it, you do it.
Lordship, may
Do it.
I briefly?
Then I'll have to recall around 3-4 orders that I have passed, wherein you have vehemently objected. But here there are documents which shows that you are considering to regularize his services. Do it. I have nothing. I'm not coming in between.
Lordship, may I briefly place the fact, lordship?
Yes. What is your final call?
Which page your lordship is referring?
I found somewhere.
Because there is already a mandamus lordship passed by your lordship way back in
93.
93.
That is no mandamus. That is only for creation of a scheme. And that scheme was formulated in 2005. Right? And there are hundreds and hundreds like you who were not provincialized, who were not regularized. So I'm requiring them to regularize your services so that the others also we can help. There is a order somewhere I found. Undertaking. Yes, Mr. Counsel, where was that
Lordship,
undertaking?
Two judgment I am referring, just two judgment, Lordship. One by
Forget
the
your judgment.
Division bench of our High Court, Lordship, and another by the Supreme Court.
That my Lord Justice Ansari's order.
That is their Lordship. Review petition.
No. I found something in pursuance to the orders of this court. The respondents have proceeded to process the file for regularization. Where did I find it? With reference, I am directed to inform you that the matter of regularization of services so and so, as per judgment dated 21/2/2022 of Honorable High Court in WPC number so and so was sent by Irrigation Department. Accordingly, the e-file was processed and returned to the so and so with the endorsement. No, finance did not proceed thereafter. But how was this file processed in the first place? By referring to a judgment of this court dated 21/2. Yes, Mr. Chutia, you are paying for? He is under you.
Appointed on 27/7/93. That is after 1/4/1993. So my lord, that regulation scheme, those were appointed prior to 1/4/1993.
He was appointed?
On 27/7/93.
Oh. Yes, Mr. Modak, what do you say?
Initially, I was appointed on 21/5/1991 also. So subsequently, I was terminated on 24/9/1991. And hereafter, I approached before this honorable court by way of filing a civil rule.
You were reappointed. So
Yes,
your
sir.
service, that 91 to 93, is there a direction of this court to regularize?
The reappointment order was not in consonance with the order passed by this honorable court.
No, this honorable court 93 only said, consider his case for regularization.
For regulation,
After framing a scheme.
this honorable court issued a mandamus for regulation and to frame a scheme, lordship.
We are not.
And lordship, that the service matter, that order was not assailed by the respondent authorities.
Need
That
not be.
appealed finally to lordship.
And you also did not, it said 6 months. You also did not initiate any proceedings till you instituted this proceedings here.
Lordship, one of the petitioner has approached.
Yes, what is the
honorable court
decision
for
you want to
regulation,
rely upon?
because his salary was held up. And for release of salary, he was to approach before this honorable court.
My sympathies are with you, but legally I can't do nothing.
And recently, lordship, the Umadevi case has been discussed by the honorable apex court in the case of Nilima Srivastava, lordship. I have annexed.
That is on a different context altogether, Mr. Counsel. I have gone through it. You have annexed it.
So Nilima Srivastava, it was held that the service matter, that's concluded, cannot be reopened.
There was no conclusion. That's my case.
Return to paragraph 16 law.
So since this honorable court set aside the termination order of the executive, so I may be presumed to be in service since 1991, lordship.
Did this court interfere with that order of termination?
Lordship,
Where is that? Sorry, I might have missed out on that.
termination and except 3, lordship,
Where is that portion wherein
page 19, lordship.
page 19 is the order? Where is that interference with the termination order?
So lordship, termination letter, page number 70, lordship, termination order, that was set aside, lordship.
Where?
Specifically, it was not mentioned, lordship.
Then neither you were, neither I was born in the profession nor you were. So what happened on that day in the court? We can only know from the order. We were not there.
So lordship, kindly come.
So
to
your
page 20, lordship.
statement that the order was interfered with has to be from this only.
Lordship, that order was assailed by way of the civil rule, lordship.
Yes. What is this orders, Mr. Naik?
Same situation, lordship. Here, the wife was approaching the court, lordship, in respect of the service of her husband. Works are not regularized.
Yes, Mr. Modak.
Kindly come to page number 20, lordship. This honorable court has held that, but by an order dated 21/9/91, their service was terminated with immediate effect.
Hence
So that
this
order was
repetition.
to silence, lordship.
Yes, that's what I'm saying, but that was never interfered with. Said, prepare a scheme and thereafter consider their cases for regularization. And that scheme unfortunately was prepared in the state in 2005. And that says 1/4/2000, 1993. And your reappointment is of a date subsequent. Do one thing, do one thing, do one thing, do one thing, read this judgment and come back at 2. Give him. Let him read. Mr. Chutia, something is there we can do for him. Mr. Nayak is retired. He served for 31 years. If we can do something as an officer of the court, come up and tell me. At 2 o'clock. Both the cases. Right, Mr. Modak, 2 o'clock. 2 o'clock. You go through that judgment. And Mr. Nayak, try to find out. Sometimes you should be a little bit more broader.
Very difficult.
But my problem is if I pass an order, then tomorrow there will be.
The court, my humble submission, Lordship, at this stage, Lordship, after 2007, Lordship,
Can't do it.
specific judgment is there. No
Upa-
court will
Upen
pass
does.
mandamus for
In my
regular.
humble submission, third gate will not open Lordship. Since there is a mandamus in my favor.
Forget it.
No
That was
mandamus
only
is
for the
there. It was
purpose of
only in
preparation of
respect
a
of
scheme.
Masood Wapar.
That is only for the purpose of
The
preparation of a
interpretation is
scheme.
up to Lordship.
Even your termination was not interfered with. They gave you a second lease of life. So your every entitlement will begin from that second order of engagement. Unfortunately.
So file was processed because your Lordship has passed an interim order in 2022. That pending. penalty shall not be
We did not pass any interim order. We only said whether your case for grant of provisional pension can be considered. If they have misconstrued the order, we are not responsible. We have not passed the direction. Only consider whether he can be given a provisional pension. They should have come up and told us because he's not a regularized employee, he'll not be entitled. I don't know why Mr. Upadhyay went and started processing the file for regularization. If you want to regularize, do it. You make a statement. We'll not come in with. Yes. 2 o'clock.
1.
Yes.
My lord. The petitioner was appointed as a PS.
Cabinet decision, 44 years.
Yes.
Now,
Then 44.
now cabinet topmost said, give him 44.
44.
Now you want beyond 44.
Petitioner number is.
Say, Mr. Counsel, here the cabinet, in your respect, had not said
My
that
lord,
the minimum age is raised to 44.
My lord, I have filed an additional affidavit. my lord.
Yes.
Page number 77.
Hmm.
Here,
Hmm.
with reference.
Additional affidavit dated 11/7.
11.
Yes.
With reference to your letter number subject cited above, I am directed to request you once again to take necessary action on prior petition submitted by Sri Nandeswar Hasnu, Junior Engineer PWD appointed under Regulation 3F for relaxation of apparatus for applying to the post of Junior Engineer Civil and at the Joint Cadre PWR in the light of the approval of the Honorable Cabinet in its meeting held on 21/3/20 at 5 p.m. at item number 9 for relaxation of upper age limit and also taking into consideration of the existing norms of the relaxation of qualifying age of the reserve category ST plain, SC, ST, OBC candidates. My lord, petitioner number 1, he is overhead and he has not selected also. But petitioner number 2, after relaxation of 5 years as a ST candidates.
You are around 50 plus.
50 plus, no, 49 actually, my lord, petitioner.
Show me the cabinet decision. Show me the cabinet decision.
Age of the petitioner number is 49 years, 10 months. He is not entitled, my lord. He
So
is not
petition number 1 out.
out.
Petition number 2.
Petitioner
Now
number
show me
2,
the cabinet decision, Counsel.
petitioner number 2, his age is 44 years, 6 months, 15 days. So as a ST, his candidates, he is getting another 5 years. 44 plus 49.
No. Show me the cabinet decision.
Cabinet decision, actually communication letter.
That is the one.
43.
43.
43. In 43, actually it was not mentioned clearly, but later on, 2nd May 2020. But later on, this letter, 2nd September 2022. Annexer I, my lord. Page number 77. And government also filed affidavit, my lord. They have admitted this.
With reference
And in
to
44 also it was stated that it is special case. Last line. As a special case.
Apply to post of direct recruitment of junior engineer civil under so in respect of the following 9 numbers of junior engineer civil. So as a special case. Relaxation of appraisal limit up to 44 as on so or apply to the post. 38, 39, 40, 41, 42, 43. Minimum is 38. Minimum age was 38. Maximum age was 38.
38.
So if a
As per the
reserve category community candidate is there, OBC, he will get 3 years. SC, ST, he will get 5 years. So 38 plus 5 would be 40,
38 plus 5,
43. So beyond that, 1 more year the cabinet had given him. So now if we ask the government to add another 5 years to this, that would be defeating the decision. Yes. What is the departmental stand? You have filed an affidavit.
Yes, affidavit now.
You have filed an affidavit here. What is your stand?
Page 43. Lord.
Page
Page
43. Yes.
Cabinet has already given approval.
That's it. How can we add another 5 years to that, Mr. Counsel? And they have participated in the selection.
Lordship, as per the orders of this court.
What is their result?
Petitioner number 2 has qualified, Lordship. Though it was asked to be kept in seal cover, however, inadvertently the result was declared, but later it was withheld, Lordship.
Give. We'll add 5 years. He is qualified, working for such a long time. How many more years you have to bear him? He is already 54. Right?
Let me do one thing. Let me have this.
We'll only take a cue from that subsequent letter at page 85.
Right. In my additional letter. And this letter is also enhanced by government also. In their affidavit, but I think their paging is not.
Annexure K. Have you got that letter?
Same cabinet meeting.
Same cabinet decision, but the subsequent tail which is there for relaxation and also taking into consideration of existing norms for relaxation of qualifying ages for reserve category, STP, SC, STH, and OBC candidates.
This is just referring to the cabinet decision.
Forget it. Your that subsequent line, that last line, that also the relaxation for SC, ST, 244 years can be read into this.
Let them decide that on this application. Did the PSC have a decision?
No.
They must have taken some decision.
No, we'll have to clarify that situation. We'll have to clarify that the government having permitted 44 plus SC, ST relaxation. He is within the limit, so kindly appoint him. You have your call on this. We'll have it day after. Day after. Day after.
Monday, not.
No. He is running. His age is running. Clock is running.
In fact, we have instructed by APSC, we have to take their instruction, not what they did.
No. It is a cabinet decision. It's you are the recruiting agency, you have to take a decision with regard to age. The APSC will just follow.
In the cabinet decision, there is.
44.
Yeah.
What is written here, if the upper age is raised to 44, 38 plus 5, now you have raised 38 to 44, so 44 plus 5. You come in day after tomorrow. On the prayer of Mr. P. Naik, Learned, Standing Council, Public Works Department, list this matter again, day after tomorrow, by slip code, file to tribunal.
Lordship on Friday.
Huh?
Friday.
Huh?
Friday.
Thursday. Full stop. Friday, somehow, second half, we will all lose that enthu.
Small instruction, please.
Thursday, huh? Full stop. Mr. Naik, in the meantime, shall receive his shall clarify the purport of the communication dated 2/9/2022 issued by the PWRD department and available at Annexure K, page 85 to the present. Page 85 in the present proceedings. Let's see if we can do something, but he is past. Clear. Okay then. 22. Yes.
Michael. So the petitioners are the employees of Food Corporation of India. In the Food Corporation, will go to the selection part.
Huh?
In the Food Corporation, there are
Lost.
4 categories of them.
Okay.
Now, one is regular department worker, they are called as departmental workers.
Yes.
Other is direct payment system worker. Though they are departmental worker, but not the regular employee, direct payment system workers, they will be paid by directly by the FCI officer to them.
Third is
And third one is the contract labor.
contract labor.
Contract. Let us confine with these 3, because so far other is concerned, it does not have any relevance so far our case is concerned. So I should not like to trouble you a lot. Now, in the instant case, what happens, the petitioners are DPS, that is direct payment system worker. They get minimum wages, and in addition to that, they get something more. They are not getting the regular wages. Now, what happened by
If there is no work, they are not paid anything.
Now, what happened in this case, Milord, all these persons have been transferred to 600 kilometers away at Dibrugarh.
Whole gang has been transferred.
Whole admin part. Now, and in that their place, they want to introduce some contract labor. Why that is? All this gang will be transferred to Dibrugarh, and in their place, they would like to introduce some contract labor.
Wherein you are posted, they are introducing contract labor.
Contract.
So for that purpose, you are taken away.
Yes, but there is a reason behind it. Reason is that what they want to say from their affidavit, though it is a elaborate affidavit, that if this contract labor and DPS laborers are allowed to work simultaneously together, then contract labor has to pay the wages that is being paid to the DPS labor. So they have to pay more.
Whether that can be a reasoning.
It appears from their affidavit.
So your basically grievance is with regard to
What
this
you-
transfer.
Transfer. Now, there is a circular, the FCI, that if this kind of DPS laborers are to be transferred, they should not be transferred more than beyond 100 kilometers. Of course, they may be transferred beyond that. But for that reason, there should have a specific reason for that purpose. Why you are transferring? What is your basic needs or exigencies? What led them to violate this circular? You should come with a proper case. Now, in their affidavit, it appears to me, at least subject to your lordship's scrutiny, that they want to say that they would like to introduce some contract labor here. And for that purpose, they want to transfer these gangs to Dibrugarh. Look, this is my basic submission. If your lordship, please hear them and be prepared. I will give my reply. They have.
So this order is under stay.
Yes.
Order is under stay. Transfer order is under
Yes,
stay.
yes, and
Now-
that observation has been made while
absolutely.
saying this order.
Now, one thing, after your continuation here in terms of the interim directions, were contract laborers also introduced
Yes.
after the interim directions? You are continuing at your earlier
Yes,
place?
still there. And most of them, about 10 to 15 workers have been retired. already.
Fine. Now, have they introduced contract laborers at your place of work after this?
That is not probably that.
Yes, Mr. Singh, what is your case?
Probably they are not.
So this is your basic grievance.
It's in simple program.
Regarding introduction of the
If required,
contract
I should-
labor, that I have to take instruction, my lord. The case,
And for that
case is
purpose,
that,
they
my
have
lord,
referred one PIL of Bombay High Court. That's it.
the case is, my lord, the pooling of the labor. There are three systems of labors working under the FCI, my lord. Now, it has to be pulled off like where one system of the
See,
labor should work
one
in a
thing,
particular
One
FSD,
thing,
my lord.
one thing, these laborers, they are maybe engaged wherein their residence or native places normally are. So we can presume that they say are working in Guwahati, so they have some sort of a attachment here. Now, if you transfer them
My
to
lord, the
Dibrugarh,
name of the
no,
labor may
if
be
you
same.
transfer them to Dibrugarh, these people would be required to maintain two establishments. One for them at Dibrugarh, another for their family at Guwahati.
My lord, if your lordship will see the name of the laborer, my lord, they are basically the outsiders, my lord, they. And they,
Either does it, may.
yes, my lord, but
But they may have a
we are
family
taking-
here.
We are taking care of the seniority of the laborers in the. gang.
Seniority and not, do they get a higher amount if they go there?
Yes, they are getting, my lord, even they are getting here also and they are also, my lord.
They'll get the same
Because
money
they-
there. Say they are getting 100 rupees here.
Ah.
If they are transferred to Dibrugarh, they'll get 100 rupees in Dibrugarh also.
Yes, my lord, their salary, their wages.
Okay,
will
what
not
is
come
your
down,
reason for this transfer?
my lord?
What is the reason for this
Yes, my lord,
transfer?
I will come, my lord, first of all, the annexure 2, my lord, at page 95 of my affidavit in opposition.
Page?
Page 95, my lord, of my affidavit in opposition.
Hmm.
It is annexure 2, my lord, 95, my lord. Guidelines for implementation of exemption notification dated 6/7/2016 under section 31 of the contract labor, so and so, my lord. Now, my lord, the serial number 4. Following steps may be taken to rationalize the existing manpower, my lord. Because in one FSD, one system of labor should work, otherwise there will be chaos, my lord. One system of labor will earn more, another system of labor will earn lesser. That's why the FCI has taken steps to pulling off the labor. In one FSD, one system of labor should work, my lord. And
So
that
what,
has-
why, wherein they are working, why that earlier system of direct payment is now sought to be undone?
No, it is still existing. Now, after their retirement, we are not taking any,
Fine, till they are continuing, why are you disturbing them then?
we are pulling off, rationalizing the one system of labor in
Fine, fine,
particular labor.
fine, but they are working today.
They are working now,
So-
only fewer people are
so-
working, my lord.
Be that as it may, 10 are working, 15 are working. When they are working with that system, why are you taking away the whole of DPS from that area?
Because earlier, already in Chapakua and Dibrugarh, my lord, DPS systems are working, my lord.
That's why I said it will
So
continue
they are
till
only-
they retire.
They are only fewer, my lord, DPS.
Be that as
So
it may.
we are pulling off the,
Because if you are, that means you are undoing, you are doing away with DPS system.
because there is a circular.
Show me
of
that
the-
decision. That we are doing away with DPS in these two stations.
Yes, my lord, I'm coming up with it one by one. my
Hmm.
lord. First of all, annexure 2, my lord, number, serial number 4. Following steps may be taken to rationalize the existing manpower. The pooling of the departmentalized laborers in poor depots may be done by making inter-depot, inter-district, inter-region, and inter-zone.
You come to clause 4,
Yes, I'm reading the clause 4.
following steps.
Following steps may be
Huh.
taken to rationalize the existing manpower.
Huh.
Number 1, the pooling of the departmentalized laborers in poor depots may be done by making inter-depot, inter-district, inter-region, and inter-zone. Here, my lord, it is inter-district, my lord.
Okay.
Then, my
No,
lord,
no,
on the
read,
next
read,
page,
read further.
inter-region and inter-zone in exceptional cases transfer from one depot to the other depots operative under the same labor system.
So you can make this transfer only to areas wherein you have this same system of,
Same labor system.
okay, that's what we understand.
Yes, my lord.
Okay. Then,
Now, on the next page, my lord, serial number 7, my lord, Roman 7. As per existing instructions, workers under the departmental and DPS category on their transfer by FCI in the interest of the administration are entitled to get weightage of seniority at the new place. So we will take care of the seniority also, my lord. Then 10, individual depot.
no, it has been decided that seniority position of so and so will
It has
not be
been
disturbed.
decided
and
that till
separate
further
items
order
are to be
seniority
maintained
position
in
of
it
group
so
of the
that it
workers
does
of the
not
gang transfer
jeopardize
from one depot to other
So-
will not be disturbed.
surplus
And
workers of
separate
one
identity
can
of
be
such
adjusted.
worker will be maintained in incoming depots. Separate identity, my lord, that they will work, their gang will be separate, my lord. Then number 10, my lord, individual depots should have single labor system and in no case labor of more than one system be engaged in one depot.
So
This is
till
circular.
they are there, you continue. It does not say that you do away with this.
No, we are not doing away with this.
Now
They will-
for
they will
you
be
to,
protected, my lord.
for you to save you on your revenue, you are,
No, otherwise, my lord, because 2 or 3 labor system are allowed to work in one single FSD because their earning will be different, my lord. They will get salary plus
whatever they get, whatever they do.
incentive is there, my lord. In other system, they will get only the whatever.
So
fixed
show me,
amount is there.
this is by the.
So we are
chief
only
general.
following the circular, my lord.
Okay, now show me the decision-making process for transferring them. Where are the records? You have the records with you?
This, in this case, record were not called for. We have annexed all these.
Show me the manner in which they were directed, that these people will be now sent to from A to B. How was that decision taken? And so, in
Yes,
other
madam,
words,
I'm
how
con-
did you apply the circulars to the petitioners here? Where is that process?
We are following all the circulars where.
That's what I want to know.
Yes, my lord. That
Annexure?
Annexure 3, my lord, at page 97. This circular is issued by the headquarter, my lord. It has been observed that even after first phase of rationalization, the earnings of the departmental and DPS labor in some of the regions are still very high. So in view of the above, it is advised that the other further rationalize the strength of the departmental and DPS labor so that they are utilized optimally and abnormally earnings idle wages are reduced.
So you will
Some
also have
Some
to,
remains idle, some remains.
fine, you
Yes.
also have to carry out an exercise to understand whether the earnings in a particular depot is very high. If you find that it is very high, then a process of rationalization is to be taken.
Yes, madam.
Where did you do that exercise? Tell me how you have done that exercise. Circulars, orders, fine, no dispute. But how have you applied that to the petitioners?
That's what I am submitting, my lord, in that particular THU's.
I want that, I want to see that.
I will bring the record.
You show me.
I will bring the record.
2 o'clock here only, Ulubari.
But it will take time, my lord. Next week.
Without that, we cannot. We'll have it on Thursday.
Thursday.
Mr. B.K. Singh, learned counsel for the appearing for the FCI authorities shall on the next date of listing produce before this court the manner in which the decisions of the Food Corporation of India for rationalization of the labor strength was so done in respect of the petitioner's hearing and leading to the issuance of the office order dated 23/3/2022. So the records in this connection be furnished before this court on the next date of listing. Also heard Mr. A. Das Gupta, learned counsel, appearing for the petitioners who had made his detailed submission in the matter. First off, raised it to list this matter again on Thursday. Thursday, date, no? Kiman? Yes, Mr. Mukherjee, this time I'll not forget your name. Yes,
The petitioners were appointed in the year 2019 in Bijni Municipal Board, and their services were regularized on 2020. Thereafter, your lordship, they were serving, and one inquiry was conducted by the council head of department. The inquiry report is at page 26, annexure 3. Coming to the findings at page 32.
Something against that chairman.
Yes, sir.
Yes.
Page 32, the summary and findings. 6.1, it says the appointment of the regularization of the 10 employees in Bijni Municipal Board was made against vacant posts as per the decision of the board meeting during the year 2016 to 20. Moreover, the staff details with total number of 34 sanctioned posts, out of which 20 are permanent, 11 are on consolidated pay, and 3 were vacant. In respect of Bijni Municipal Board, as on so and so. As much as the number of employees in Bijni Municipal Board is seen.
You are
it
reading
appears
at
to be
page?
Below the prescribed.
You are reading at page, Mr. Mukherjee?
Page 32. The summary of findings.
Okay, huh. Visit on.
Summary findings and observations. 6. Subsource to your lordship. As much as the number of employees in Bijni Municipal Board is seen, it appears to be below the prescribed staffing pattern as proposed and suggested in the report. So and so, as per the population. So, it's below the staffing pattern. Thereafter, your lordship, based on this report, your lordship, page 37, annexure 4 was issued, which says, annexure 4, page 37. Which says that these 10 employees were illegally regularized. I don't know on the basis of what. And thereafter, page 38, your lordship, says that in view of the findings, the regularization, the illegal regularizations are set aside, are cancelled with immediate effect. Without any.
When was the regularizations? 20.
20.
Cancelled in 23. You have the power. Don't worry. But where is the notice? Where they put to notice?
The date is not.
Interfere with that. What is your stand in the affidavit? What is your stand?
So, my estimate was, the selection process and regulation is not done in proper way. No
Fine.
advertisement.
Give him a notice and thereafter do what you want to do. Without notice, how can you?
Yes, ma'am.
That much only. We will interfere with this, direct them that if they have materials, they will first issue to you a notice, hearing, and thereafter proceed with whatever manner, in a manner known to them. That much only.
Lordship, one more aspect.
Huh.
After this, your lordship, page 39, the final order. In the previous page, page 38, our regularizations were cancelled, your lordship. And immediately we were released from the service, your lordship. So even if our regularization is cancelled, we may be continue.
You have not been even continued as a,
They're not allowing us to enter the office, your lordship.
right?
They are released. As per,
Okay, when was, naturally the decision would, once the matter is, you are regularized, Where are your regularization orders in the record?
Page 22 to 25.
Now, Mr. Counsel, is it your case that this orders issued by the chairman, there was no resolution of the board to that effect?
My lord, I think,
There was a resolution, Mr. Mukherjee,
Lordship,
before this. Where is that?
Lordship, that is not annexed, that is
my
not
lord,
within my, they have also not
Chair-
placed anything.
chairman and CEO, response from chairman and CEO is necessary, my lord. They are not appear.
Forget it. We don't want it. We want a board. Now you just find out whether prior to issuance of this regularization orders, because the chairman on his own sweet will can't do it. It has to be done by the board. There were any resolution of the board. If there is no resolution of the board, we may even reconsider our decision to interfere with this order. We may not interfere. You get that decision, whether in writing, whether the regularization of the petitioner's hearing were in pursuance to certain directions or decisions of the board. Can you get it?
I will collect, my lord.
Not try, you'll have to.
Not
And you will have to give me in writing if
Yes.
it is not there. So, on the next date of listing, the Standing Council BTC, Mr.
RK Musari.
R.K. Musari, Learned Standing Council, BTC, shall receive instructions from the Bijni Nogor Bijni Municipal Board as to whether there were any decisions of the board preceding the regularization as effected in respect of each of the petitioners hearing. Also, they said instruction shall be placed in writing from a competent, shall be received in writing from a competent authority of the board and be placed before this court on the next date of listing. Registry to list this matter again on Thursday, Gaurav. Thursday,
First day, my lord,
Friday,
Friday, next week, my lord.
Monday.
Monday.
Let's see, Mr. Abdul.
24 to 26.
I talked with the client, my lord, but he said, my lord, leave it up to the your
Okay.
lordship.
You agree. Yes. Switch on the mic. Who is appearing for the central government? Mr. Gogoi, you are appearing. What is your stand? Your stand is that because of that Talake-Bian certificate that was given, but that is possible.
Whether that can be treated as a lordship.
Not only that, he has not brought that on record in
Lordship.
any of the proceedings and there is no material
Lordship,
to show that. So initiate proceedings against him.
Lordship.
That's all.
Yes.
We'll allow the prayer of the petitioner here.
Otherwise,
And one thing, my lord, the petitioner already.
indicated our.
Already came in BRS, my lord.
Oh, already BRS.
Yes, my lord, 31st of May, my lord.
Then lordship. Then lordship have to adjudicate.
No, but you can't proceed him against them now.
That's why lordship have to adjudicate. Whether that can be treated as a valid.
We'll only declare that so Mr. Islam, in this situation, that he is not there, I think you should institute a appropriate proceeding in the civil court.
At least
Declaring for declaration of a right, that we will not do it here. That he is in service, so I could have done a part that we could have directed for appropriate proceedings. That we cannot now.
Even lordship, the Family Court Act itself says that lordship have to approach the appropriate jurisdiction. Even Honorable Bombay High Court also.
My case was, my view was that he is in service, so we can proceed against him. Now that he is already, that master servant relation is over, we can't direct them to institute appropriate proceedings.
Lord, other benefit can be, my lord. If suppose he is alive, so no issue. After he expired, my lord. So
For that, you will
my
have to.
status may be declared, my lord.
No, you will have to go before the trial court.
Yes.
You will have to go before the trial court. Think over it. We'll have it day after. You think
You
over
have
it.
to approach the jurisdictional family court.
Family court.
Otherwise, Honorable Bombay High Court also decide the issue lordship that talaki benefits cannot be treated as a document lordship.
It cannot.
Until and unless it was declared by the appropriate court lordship.
It cannot be. So, in that view of the matter, in this changed circumstances,
Lordship.
let me also think over it.
My lord, impugned order issued without hearing me, my lord. Without
No, no.
giving me any
The
opportunity.
impugned order, Mr. Islam, for your satisfaction, even if I interfere with that,
My lord.
that will not give you. The only relief now that you can get is to get back into the service records as his first wife. Right? Nothing more, nothing less. But for that, again, nomination, if the second wife is also there,
My lord.
now I cannot direct the authorities to proceed against him. I'll also think, because I was formulating my thought on the premises that he is already in service.
That I also thought that lordship was in service lordship.
If he was in service, then what I said in the morning, 2 minutes, we could have done it. Right? The only, but now that circumstance. Anyway, let me also give it a thought. We'll have it on Thursday. As prayed for by the Mr. Gogoi, you also be here on Thursday. Registry to list this matter again on Thursday. They give a date to deliver for further consideration.
Highly obliged.
এটা ওপৰত থাকি গৈছিল নহয় এইটো কেতিয়া দিলো আইটেম নম্বৰ 2 আইটেম নম্বৰ 4 আইটেম নম্বৰ 4 টো কেতিয়া দিলো 4 কালি দিছো নি
My lord, in item number 23, kindly come to order dated 14/9/2022, passed by your lordship.
in this proceeding, in the present proceeding. 14.
Item 20, lordship. In item 20.
What is the case number?
2804, lordship.
Order dated
Order dated 14/9/2022.
14/9/2021.
22. Since there is a judicial order passed by your lordship, let them file an affidavit, lordship.
There is a reiteration of that earlier 93 order.
Lordship, may kindly see the judgment, Lordship. Lordship,
I've seen it.
Lordship,
No doubt on that.
verification.
No doubt on that. Scheme 6 months, no doubt. But 14/9/22, this court, there is a judicial order that you have to file an affidavit.
Affidavit. I will file, Lordship.
File it by next week, by Tuesday. We'll have it on Thursday. I'll dispose it of, don't worry, but just comply with that
Lordship will
order.
grant me some more time, Lordship. Parawise, I have not yet received, Lordship.
Only on a
So
legal
otherwise-
point you have to
otherwise, I
file.
was thinking that only law point.
No, no,
involves,
no,
Lordship.
you will have to file the affidavit also in compliance with that order only, how you have implemented, that's all.
No, only.
You have
submission
to
will be-
only say that 2005 only this scheme was.
Lordship, only submission will be whether but my filing of an affidavit will.
No,
give
I
me
only
help
want
his
that,
case,
that
Lordship.
order to be formalized because there is a direction. And our court having passed an order, we will want its compliance.
Lordship will grant me some time then, Lordship.
See, I'm fresh
will-
with
I
the
will-
matter, I'll forget.
Lordship,
I'm fresh with the matter.
Lordship will remember, Lordship.
I'll
There's no
forget.
point is involved.
As
Lordship will grant
Mr.
2 weeks time, Lordship.
Naik, learned counsel appearing for the PWD authorities submits that he be given 2 weeks time to bring on record the affidavit on behalf of the said authorities in pursuance to the directions passed by this court, while order dated 14/9/2022 in WPC number 2804/2022.
Lordship, it will be irregular, Lordship, and my friend will file, Lordship. I'm appearing for finance law.
Okay, Mr. Anupadhyay. Anupadhyay, everybody. Anupadhyay submits that he be permitted to weeks time. Also heard the learned counsel for the petitioner and also Mr. P. Naik, learned standing counsel, finance department, and also Mr. B. Sharma, learned counsel appearing on behalf of the AG authorities, and Ms. Kemprai, S. Kemprai, learned counsel appearing on behalf of the
Yes.
Karbi Anglong Autonomous Council. And Mr. Borua, you are paying for? And also Mr. B. C. Borua, learned counsel, standing counsel, Ekalinga Board, standing counsel, so and so. List this matter again on when?
2 weeks left.
But Mr. Upadhyay, this time, if you don't file, we will impose costs.
No, I'll file.
List this matter again on 14/8/2024 as a part heard item.
Order 14, I have an occupation, pre-occupation.
14, then when you are free?
16 or 17.
16. 16 as a part heard item.
16.
Part heard no, for further hearing.
May I please your lordship? Your lordship, she is on leave, your lordship. I already communicated with it, your lordship, regarding this arising issue, your lordship. So kindly grant us 1 week time, your lordship.
Yes, Mr. Sama, you are paying for?
And for demands of.
What do you have to say?
You have received that proposal. Proposal, we have received the proposal.
From?
Secondary non-formal education.
What is that proposal?
It below, I already submitted it, your lordship, before you.
Before this today?
Yes, your lordship.
Sanctioning the provisional pension.
Oh, that one. That is gone now. That we are not interested. That you do it, but we are not interested. We want to finish up the whole issue. Next week when? I don't want any instructions on the provisional pension, madam. But
Your lordship, court order may be needed, your lordship. Today's honorable court order will be needed, your.
for what?
Lordship, to pursue your lordship, we're releasing that matter, your lordship.
Madam, you do whatever you want with the provisional pension. We are now beyond that. We are with the final pension. I'll not put you to inconvenience. I'll have this matter again on Friday. And on that day, we'll dispose of the writ petition. Right? Anything you want to do, do. So, as prayed for by the Learned Council for the parties, list this matter again on Friday. Mr. Sharma, both Sharmas, anything you have to assist, assist.
My lord, it's fixing on Friday.
Friday.
This
Any
Friday.
problem, Mr. Gush?
No, my. Presence will be reported.
So what did you do? C. Sharma for the Dima Hassan, Mr. B. Sharma for AG, Ms. Das Pri Das for Standing Council Education Department, and Mr. B. Ghosh, Learned Advocate, appearing for the petition. Itu letter to put a select.
My lord, I don't have any updated instruction. This is the instruction of 9/4/2024. That is what I can.
Where is that letters you gave me?
Yes, my lord. It is here, my lord.
You want your money. That's all. No, there was a letter from the address to Mr. Hazarika. Where is that letter? Mr. Hazarika? I think I gave it back.
Mr.
Oh, no, Mr. Borpuzari. There was a letter addressed to you that we have sanctioned so and so amount.
The second page, I think, my lord,
This
this
one.
is not exactly addressed to him.
Oh, no, it was in the other case. No, there was something now. We have sanctioned so and so
Yes,
540 crores. Where is that? 564 lakhs. Yes.
Yes, my lord, 564, that we have. my lord,
57.
9/4. One is 9/4.
1 crore 41 lakhs.
That is, my lord, 25% of the budget, my lord, that we can, my lord, draw in the.
What
first
is the
fiscal year.
total involvement in all these cases? Total involvement in all this series matters. How many are there? So this is specifically against court cases, against these cases.
My lord, that they will be able to. my lord.
Yes, madam.
Earlier patent interpretations, the government has sanctioned us money and we have deposited.
I got it. I got it.
This is the second patent interpretations and we have.
So this amount is for these petitioners. Can I record that statement?
It's
then-
already written. I have submitted 2 documents, one of 2
Raman, this is 5/7/2024.
This is the second time we have asked them to pay. This is the second installment money.
So you mean to say that this 1 crore 41 lakhs will cover all the writ petitioners? Sure.
Dispatch of interpretation.
Dispatch of writ petition.
Names are mentioned.
Where?
I have submitted, the names are mentioned there. Lordship, this is not the cleared one. In the paragraphs, the names are mentioned, Lordship.
Okay.
Page 2.
Mr. Sharma, check up. It is minimum some retirement wife, so. 209423. Available? 5643. I don't know. You just check the cause list. Just check the cause list. 209423. Asa? It's there.
Names are there, lordship.
The present writ petitions are mentioned. How many are there? Kimatiketa writ petitions, sir? 8. 3,
Lordship,
5.
28 is Saniram Boro.
Ah.
It is there.
It is there.
24.
Then
in serial.
Madan Chandra Besbarua,
Madan
Saniram
Chandra
Boro
is
is,
in 6,
okay.
lordship.
Kali Saran
Then
Boro,
Kali Charan is in 7,
hmm,
serially 7.
hmm,
Then Naren Chandra,
Boro,
Naren
Baro,
Chandra Boro is on 3, serially 3.
hmm,
Then Uddhav Chandra is in 5,
hmm.
serial number 5.
Sonali Dewari,
Sonali Deori, lordship in serially 8,
it's there.
serial number 8.
Then 609.
Rajeshwari is in serial number 9. Shainavi is
Deori.
in serial number 11.
Hmm.
Rudra, lordship this much only.
Hmm.
And other cases are also pending.
Fine.
We have already submitted the second installment. First is dated 2/5/2024 and the second is dated 5/7/2024. Lordship, now the finance department will be able to say
What?
when they will sanction the amounts and when we will credit.
Here, my lord, the role of finance department is not with regard to sanction. It is only will be, my lord, with regard to release of the money per se. At the stage of, my lord, fixation of ceiling.
But here, what is the effect of this letter 5/7/24, wherein they say the managing director APDCL has said that so and so have the honor to submit your proposal for signing. This is only a proposal.
Yes, Lordship. Lordship.
This is not the
earlier-
final one.
Lordship, in the earlier order, it is reflected that on 10/4, we have made proposal for 564 lakhs. Then they said, it was said by them that quarterly, we will sanction the money quarterly. Then we have submitted 2 installments. First is the dated 2/5/2024.
That has been released to the petitioners.
No, Lordship, it has
has
not
not.
been released, but we have already asked them to release. We will.
The respondents. Mr. Dhar, you are appearing for?
I'm appearing for 1 and 3, my lord.
The Mr. R. Dhar, learned counsel, appearing for the respondents 1, 2, and 3.
1 and 3, my lord.
1 and
3, my lord.
3. And Mr. Bor Abu Pujari, learned standing counsel, finance department, appearing for the respondent number 2, shall receive definite instructions as to the manner in which the proposals as submitted by the Assam Plains Tribes Development Corporation for release of amounts for satisfying the for clearing the dues in respect of the petitioners herein has been submitted by the so-and-so APTDC has been so processed.
My lord, for that, my lord, with all respect, my lord, I do not need any instruction. In fact, my lordship can record my submission even. Now, what happens here, my lord? The corporation will send the, my lord, all the details to the directorate. The directorate will send it to the government for necessary sanction. So far as sanction is concerned, now, my lord, these all these powers are delegated. Finance
So
department.
you are not no longer doing.
No longer, lordship can record my submission 100%. Then, my lord, finally, when the government, at the government level, that is the administrative department out here, with my brother is appearing, my lord, they will have to send a FOC proposal to the finance department. And if I am having, my lord, data of that, at least the number of that FOC proposal, right now I can telephonically get the instruction. Our role is limited only to that
Okay.
extent. Lordship will record.
Finance na lage.
Lordship will
And
record.
horrible level. As to the manner in which the able proposal has been processed. This said instruction be placed before this court on the next date of listing, that is, registered to list this matter again on 5/8/2020. But what is this 9/4/24 with reference? So I am informing you that as per budget allocation, an amount of 564 only has been allocated for payment of due area salary, so and so, as well as area salary. Submit a proposal for payment of due area salary and retirement benefits, so and so. It is seen from a communication dated 9/4/2024 that the government had sanctioned an amount of rupees 564.00 lakhs. 564 lakhs, huh? For the year 2024-25 for payment of due area salaries and retirement benefits to retirement benefits in respect of employees of the APDC Limited. Full stop. The managing director APDC Limited had submitted a proposal for sanction and release of 141 lakhs out of the 564 lakhs as sanctioned in the budget for payment of area salaries and retirement benefits to the petitioners involved in the present proceedings, and the same was so made to the Directorate of Tribal Affairs, bracketed plain, Mr. Thor, learned counsel appearing for the respondents number 1 and 3 shall receive instructions in the manner the said proposal now submitted by the managing director in APTDC Limited. White communication dated 5/7/24 has been so dealt with. List this matter again on 5/8/2020. So 564 is already given. You only have to take up, you only have to give a clearance, they can be paid. We'll close the matter. Serially query. 5/8. Yes, Council.
Worship, this matter pertains to fixation of pay in arrears and pension at revised scale. Worship, if the Lordship may kindly come to page number 22 of annexure 2. Lordship will see that while I was serving as a defense civilian employee at Masinpur, Silchar, a list was published of a grant.
Now, who is appearing for the respondents? Have they disposed of your representation, earlier representation? Yes.
This is the second round of litigation, Lordship. Earlier, after first round of litigation, no fruitful action was taken by the respondents.
They have not passed the final order in terms of the earlier directions
They
of this.
passed the speaking order.
Where?
That is at page number 41. Lordship.
But this is again consideration. This is not final.
Yes, for consideration.
Who is appearing? Ms. Gan, you are appearing here. Director General Ordnance Services. Have you instructions?
Yes, ma'am.
Ms. A. Gain, learned counsel, CGC, appearing for the respondent, submits that she be given 2 weeks' time to receive her instructions in the matter. Also, raised it to list this matter after 2 weeks, immediately on conclusion of 2 weeks from today.
Obliged.
In this case, Lordship, I have received the instructions. I'll file an affidavit, Lordship. 2 weeks' time may be allowed.
Who is appearing for the mother? Who is appearing for the mother? Steps have been completed. Somebody is appearing. Item number given it 38. Mr. N. Kolita. Yes, what is your instructions, madam?
Instruction lordship, he was an MPWM under, Rampur BPHE. But there is no record, that he is married or not. Service book is also sent to me also, as the court, on the court order.
But there is a adjudication by the family
And
court
mother
with
is
regard
also
to
claiming. Mother
for
is also
maintenance.
Maintenance,
So that is enough.
yes.
So have you processed the family pension matter?
Not yet, lordship,
Why?
because mother is also claiming that is right, lordship.
So take a call. Mother is also a first class heir. She is not looking after her mother. Naturally, they are not staying together. Right?
Yes.
So she'll also get something. But she being the wife
Wife,
would
lordship,
have a preferential claim.
yes.
Okay. Get the counsel for the response. Inform the Mr. Kolita. Inform him. We'll have it on Monday. We'll
No.
Mr. You need not just give me those instructions. You don't even file a affidavit. The learned counsel heard the learned counsel for the petitioner and also Ms. Bora, learned counsel, standing counsel, health department, appearing for the state respondents. None has appeared for the respond number 4. Accordingly, register to list this matter again on 5/8/2024. On the next date of listing, an endeavor would be made to dispose of the present bill.
May it please your lordship, on last occasion, before my learned senior start matter, on last occasion, this honorable court has raised a question whether daughter-in-law is entitled for compassion appointment or not, my lord. Lordship, may I submit, my lord?
Whether she is a petitioner or I'm the.
No. She is answering to my queries.
Yes.
You relax.
Lordship, on last occasion, I have provided a copy of the office memorandum dated 1st of June 2015.
It is there in the annex, page 41.
Page to page. Page to page.
Just tell me whether daughter-in-law is covered by that scheme or not.
Under this scheme,
Not.
Lordship may kindly have a look, page 41 of the writ petition. Last paragraph, my lord.
Oh, this is again 143
My lord.
of the pension rules.
Yes. 143 pension rule never said.
Yes, Mr. Bhuya.
My lord, I have come with some judgment, my lord.
You come with anything. First, satisfy me that insofar as the office memorandum and the 143 of the rules are concerned, pension
My
rules,
lord, that-
whether daughter-in-law is involved.
Yes, my lord.
Yes, involved.
Under the similar circumstances,
First, give me an answer whether that is covered or not.
it has to be covered.
Oh, whether it is covered or not. Whether
It
the
is covered.
No. The daughter-in-law is mentioned as one of the heirs.
No, it is not.
That is the first answer.
But
So it is
dependent
not.
meaning is
no,
there.
That is the first answer. It's not. So you say in similarly situated circumstances, similar rules, there are some judgments. Show me that.
Yes. In the nutshell, my lord, I like to apprise my lord. Sorry, please. In the nutshell, my lord, in the sense, my lord, a similar circumstance, a case was held
Hey,
before,
pension rules to some. Pension
before
rules.
Honorable Single Judge in Allahabad High Court, thereafter full bench, then it has gone to Supreme Court.
Supreme Court, what did it say?
Supreme Court, my lord, did not interfere, my lord, meaning thereby the order of the full bench remained. There are 4 judgments I have come with, my lord. Yes, na. Baba. So, tension will be. Very dependent. सब की tension.
What was your husband doing?
Husband was, he was not doing anything, my lord, he died.
Because of not doing anything.
He was not doing anything.
Means he was
And
not
my
employed.
mother-in-law-
He was not
mother-in-
employed.
And my mother-in-law was working. She died. And there is none, my lord. I am widow with 2 children. And totally dependent upon her. my lord. That
So
judgment-
what I've little bit understood,
My lord.
that these decisions have interpreted the word dependent,
Yes,
not the word hire.
yeah, my lord.
It
Yeah,
has
my
not,
lord.
yeah,
I
heirs have not been defined, have not been, that matter was not looked into from the angle of heirs,
Well-
but it has been looked into from the angle of dependence.
Dependence. And now, my lord, it says notification, my lord. So only one of the page 41, my lord. Only one dependent of the family member. Dependent family member means a person who is the dependent on the government servant at the time of that.
So you mean to say that this is not just indicating, it's not inclusive, it's
Right.
indicative.
My lord.
Yes, madam,
There are other, my lord,
you go through these judgments once.
four judgment I have given. my lord.
Judgment in favor of the petitioner, Allahabad High Court.
That is the
Paragraph
one.
8.
Yes, 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 I have given.
Push, this is,
Naam to Goa.
UP Power Corporation.
Naam to Goa.
UP Power Corporation versus.
Yes, yes, I
Mata
have given.
JV. Paragraph 8, my lord.
I have given, my.
But in this case, my lord, the OM has been challenged. But here the OM is under challenge.
Itu milik. Untuk
And lordship, we have a very
Yes.
limited role. We only forwarded their petition to the DLC. DLC has considered her case.
my case is otherwise DLC recommended. SLC did not. And your lordship had to examine one aspect also. Now, my lord, dependent has been covered by the judgment which I relied upon full number of judgment. Though relating to the full bench of also, my lord, that was upheld by division bench. my lord,
SLP
that-
was dismissed.
Yes, lordship will see, I have given a division bench judgment, my lord. 119 of 22 at inner page of 12, lordship. Can you have a look? Last paragraph. Paragraph 15, my lord. Further observe that the judgment rendered by Shahila Devi in the honorable division bench in the case of where the mother-in-law died and her son-in-law expired thus, the widow daughter.
Got it, Mr. We have got your point.
Yes, I have given other three judgment also, my lord, altogether.
But I remember, not been forgot it. The word dependent was interpreted by Supreme Court. And I think in that judgment, it was said that it has to be in terms of the rules. There were some rules which was pointing to. So you cannot read into that. Okay. Let me go through the judgments first.
Because my lord, lordship will see, for a moment, my lord, for a glance, my lord, lordship, kindly have a look.
No, I got it, Mr. Sir.
Para 12, my lord. It has been
Facts, there is no
projected, my lord.
dispute.
It has been upheld by the apex court.
Facts, there is no dispute. The only question is whether
Yes.
into
dependent.
143 I can read a daughter-in-law.
Yes, my
Because
lord.
this judgment will
Yes,
have
yes, that has been
a
discussed.
wide ramification here. Do you get my point?
Yes.
This will not be a decision for compassionate appointment. Even it will have an effect in
Other
143,
cases also.
143 also
Yes.
of the
Yeah,
pension
my
rules.
lord, one of the judgment, my lord, lordship will see, my lord, which I
I'll
have
go
put like. There, my lord, it has been directed to the government for incorporating daughter-in-laws. But it is unfortunately in the state of UP.
Mr. Nayak, this decision will have some ramification. You are standing counsel finance.
Okay.
The pension rules are basically amended by you.
Lordship.
So please address also this court on this point, whether a daughter-in-law, he has relied on some judgments of the Allahabad, well-reasoned orders. So you also make some research, assess this court on the question whether only by looking at it from the angle of a dependent, a compassionate appointment can be directed. Because normally this court also was of the view that it should be from the angle of heirs, not the dependents. Basically, heirs who are ordinarily dependent. Other than that, it should not be. So my query was on the last occasion whether a daughter-in-law would be an heir in these circumstances, service law. Now he has brought decisions. So you also examine. We'll have it on 6th.
Sixth, my lord, I will not be there, my lord. Lordship either fifth or 7th.
5th.
That will be.
As prayed for by the Learned Council for the parties, list this matter again on 5/8/2024. The raised it to reflect the name of Mr. P. Nayak, Learned Standing Council, Standing Council, Finance Department in the cause list.
My lord, in this regard, my lord, another instruction will be required because I belong to a district council, 6th schedule area. What is the role of the state? That also have to be examined.
We will come into that after we get over this hurdle. I think that can be answered straightforward. There is no
That
problem.
cannot work.
If you can just give him a copy, or he just
I'll
give
give the citation, my lord,
Citation,
hard
sir.
copy.
Mr. He'll give you the citations. Copy, there is a facts, there is no dispute. Only that office
Exactly
memorandum of
identical.
2015 you will have to peruse. That madam can give you. You give him the citations.
Yes, I'll give it.
Item 40.
In this matter, PWD department has filed a affidavit lawsuit. Can I pray for 3 weeks time to file rejoinder of the affidavit lawsuit? Some subsequent development has taken place lawsuit. Rejoinder is required to file.
Okay, show me the law for your regularization. Forget the affidavit. I'm not even going into that.
Law lordship, may I refer one annexed lordship of my writ petition lordship. Lordship piece 22 lordship for a moment lordship.
Upendas will hold the field. I can't go beyond Upendas.
No, lordship, there is a, my case is different from Upendas case.
Oh,
Lordship.
oh.
Because lordship, my appointment was made pursuant to a selection process lordship.
Fine.
Because, lordship,
But
there
you
was
were again not regularly appointed. You continued in your services. You approached this court for the first time, maybe in the year 18.
18 lots. Right.
So
Yes, sir.
therein also you prayed for regularization.
No, Vendor judgment came in the year 2017 lordship.
Be that as it may,
Thereafter,
be that as it may, what is your prayer? Regularize.
regularization.
In case of similarly situated person, so and so, so and so. So we can't regularize your service in view of Upendas. Only way now is
My lord,
take the order, challenge it, get it referred to a larger bench. That's all.
my petitioner was,
Matter is pending in the Supreme Court, Mr. Naik, or dismiss. Pending.
my lord, petitioner was appointed against the sanction post lordship. He was appointed against the.
How does it change the character?
My lord, because there was an advertisement lordship. Pursuant to an advertisement lordship, selection process was made lordship. And pursuant to High Court order lordship, he was appointed in a sanction post lordship.
Where is your appointment?
East lordship 17 lordship, for a moment lordship.
Huh? 17.
Page 17.
That is the High Court order.
High Court
Where
order.
is your appointment order? 22.
Appointment order lordship, page 22 lordship. Here is also lordship, it is clearly indicated that the petitioner was appointed in the.
Mr.
result of
Bhuya,
it. My lord.
have you read your appointment order? Is this a regular appointment? Is this a regular appointment?
But this appointment was made lordship pursuant to the selection process lordship.
This is of no consequence. You were appointed against leave vacancies.
And lordship, here lordship, 9 petitioners opposed before this honorable court lordship. In the year lordship, thereafter lordship, out of the 9 lordship, services of 8 petitioners were already regularized lordship. Only lordship petitioner is left lordship. Already lordship, 8 services of 8 petitioners have been regularized lordship.
Oh, affidavit filed only on 17.
Yes, my lord.
Okay. Mr. D. Bhuya, learned counsel for the petitioner, submits that an affidavit on behalf of the PWD authorities was filed on 17/7/2024, and accordingly he prays that he be given a week's time to bring on record his rejoinder thereto. Prayer accepted. Raised it to list this matter again on 6/8/2024.
Highly obliged.
42.
May it pleases your lordship. Lordship, the government has yet to file the affidavit in this case, your lordship.
Yes, Ms. Gan.
Well, some time may be given to take instruction regarding the rejection of their prayer. State has already filed their affidavit.
Ms. A. Gain, learned CGC appearing for the respond number 1 submits prays that she be given 2 weeks time to receive instructions in the matter. Full stop. Ms. P. Hajorika and Mr. J.K. Goswami. P. Hajorika, learned counsel for the petitioner, and Mr. J.K. Goswami, learned additional senior government advocate, Assam, is present on behalf of the respondents number 2 and 3. So, registry to list this matter immediately at the conclusion of 2 weeks from today.
Should we fix a date?
Come, let them fight. This is a long pending matter.
Yes, ma'am.
Their
Please.
grievances are, it's
After
pending
this,
for a
they
long
will-
time.
Positively, I'll take instruction after 2 weeks, ma'am.
I think it's high time.
Yes, ma'am.
They have been working for since long.
Yes, ma'am.
If you don't even increase it, it's a high time for a revision. 10,000 rupees, how do you expect a person to work 6,000 and they have enough work there? It's not that they are made to sit idle. I know that. So please
Yes, ma'am.
impress upon your
Yes,
authority.
ma'am.
We'll see, madam.
Prisoner claiming pension and GIS and gratuity in claim.
Pension has been sanctioned.
Till now.
Yes, sir.
Yes, Mr. Goswami. You are the
Petitioners,
petitioners. You are, how are you related to the deceased employee?
the parents and second wife children's.
Huh?
Second was three minor children from second wife and parents. Oldest parents 90 years and 80 years.
One is the mother.
One is the mother, father,
Two is the father.
father.
3 is the second wife. Sangita Bora Soikia.
Second wife,
And 4, 5, 6 are
minor children.
the first wife is respondent number 6.
7 and 8 already major. 7 is the daughter of this.
Yes.
Your Lordship, I am for the private respondents, that's for those 6, 7, and 8. Your Lordship, in this matter, if your Lordship may kindly take the cause title once, your Lordship, at page number 3, your Lordship. Lordship, the impugn order dated 22 June 2023, passed by the learned district judge against the petition under section 372 of the Indian Succession Act. To date, the petitioner herein, they applied for the succession certificate, wherein we were the respondents. And succession certificate has been issued to all of the legal heirs. So they are impugning that order.
They are not making a challenge. They have just written there. But there is no relief claimed in that connection. They only want the pension.
Your Lordship, the pension.
They are also entitled to pension. And she being the first wife, she will have the first claim.
I am the first wife.
Oh, sorry.
I am the first wife.
First wife would have the first claim.
First
Then
wife.
only
So left me more than 10 years, 15 years ago.
who?
My first wife. But this is first wife. Now parents and minor children is resided with the second wife. But pension will be claimed by the
Because
parents and the minor
they are
children.
only
Which is the department?
Your Lordship,
Department,
The Assam Police Lordship.
Assam Police.
Yes.
Multiple pension orders cannot be issued.
Lordship.
So pension will be issued in your name.
Yes, Lordship.
Respondent.
You will distribute the amount to them.
There is no problem on that, Your Lordship. But there is no cordial relation, that is the problem.
No, no need to have a cordial relation. Only the
Yeah.
account transfer has to be made.
I'm ready, Your Lordship. I'm ready on my part. Even the gratuity and others. Your Lordship, may
Everything.
kindly have a look at the family pension order and the gratuity payment order.
PPO has been issued.
Yes, Your Lordship, in March 2024. FPPO and the GPO. First page, Your Lordship, is the FPPO. It has been released in the name of the first wife, that is me. And the Lordship, if Your Lordship kindly takes the second page, therein the legal heirs are given, the gratuity.
Including his side.
Including them.
No, not.
So this money has been released to them.
Yes.
No, it has come to you only. Gratuity money has come to you.
The provisional gratuity.
Huh?
Yes, Your Lordship.
And have you given them?
The gratuity, whether it has been received, that instruction I don't have exactly.
Get your instruction.
Yes, Your Lordship. That instruction I can get in 10 minutes, Your Lordship. This instruction, whether gratuity has, provisional gratuity has entered.
No, this is final gratuity. Provisional gratuity was given to you. That might have been, that has been recovered.
Your Lordship, the final gratuity is not yet released. Only the pension order has come.
No, 5,13,496 has been released.
That's the provisional.
Huh. That is also the money.
Yes, money.
So you are holding it for them also. So transfer to them.
Yes, if I'll, Lordship, I'll give it 10 minutes, I'll take the instruction whether this has come in my
This has
account.
been given, don't worry.
But then we
So how will you make that transfer?
their online account numbers and all the details may kindly be given to us. And we'll do it.
Give you.
Okay, if they will provide it, I have no objection.
Yes, yes.
But without a court order, they will be provided or not?
Yeah, definitely.
Arey, madam, you give me your bank account details. Whatever is there in terms of that succession certificate, they will share. Right? Tomorrow, day after, can give the bank details.
Yeah.
First,
Day after tomorrow.
Lordship, first, he have to take the instruction whether that was given or not.
No,
If given.
no. PPO has been issued. So the pension that will now flow along with commutation, whatever it is there. Everything amount that is involved in terms of the succession certificate, that will be released to the heirs. She can give one number for all of them.
Also, this amount has not been released in terms of the succession certificate.
Need not be.
Because
This
of the
amount is
other-
released in terms of your husband's or the deceased employee's entitlement.
Entitlement.
Okay, we'll have it on Friday. You get your instructions. both of them. As prayed for by the Lanark Council for the parties, list this matter again on Friday. So I'm keeping this document on.
Yes, Your Lordship. Okay.
Highly objection.
24.
We have the matter relating to compassion appointment of petitioner Lordship. Lordship, last week on the study council of Poyas event. Take time for obtaining instruction. Lordship, petitioner's name recommended by the SLC on 13/8/2014 Lordship. It is similarly situated case already disposed of by coordinate bench, that is in case 73.
Death, 2004. The father died in 2004. Right? Then what happened?
The petitioner applied for compassion appointment Lordship
When?
on 7/4/2022.
2004.
7/4/2004.
Then what happened?
Then Lordship, the SLC held on 13/8/2014.
13/8/2014. What happened? Rejected.
No, Lordship, name recommended Lordship.
DLC,
SLC,
SLC. Then what happened?
no appointment has been made Lordship. Also, SLC recommended his name, page 41, the 11 post.
Page?
Page 41, the type rating. His name, CL number 97.
Yes. Mr. Bhattakar, what is it?
That is already disposed of by a coordinate bench. 73 is the case order.
Lordship, this minutes that has been relied on, Lordship, this is not an SLC minutes. It does not bear the signature of the Chief Secretary, Lordship.
Where is the minutes?
Minutes also at page 38.
Okay, agreed. You were recommended in 2014,
14.
right? What did you do from 2014 till
So I-
2024?
They have not.
Compassionate appointment, there is no need of compassion today because
I
that
have-
period
I
is
have
already over.
The financial position also, Lordship.
Can't help it.
But similarly, security is already disclosed by coordinate press by directing its respondents to implement the SLC. 13/8/14 also, that is page 73. Same SLC also. Paragraph 3 also, by resolution adopted in a meeting held on 13/8/2014, the SLC recommended the case of the petitioner for appointment against vacancy for grade 3 was in the year 2010. Now the staff recommendation, no action has been taken.
Yes, Mr. Bhattakar, where is your affidavit? You have not filed an affidavit also.
Last
But,
page 74.
huh?
Situator does.
If required, Lordship will file an affidavit.
If
but-
required, that is not for you to decide. If you don't want to file, tell me.
We'll
We'll
file.
proceed. And I don't want an affidavit. I just want a verification of this as to why he was not appointed if there was a recommendation in his favor.
Lordship, this one, this does not bear the signature of the SLC authorities, Lordship. This has been done by a conservator and this cannot be regarded, Lordship, as an SLC minutes.
This recommendation sheet for appointment on compassionate grounds.
It is an annexed
There is a compilation. It is annexed to
page 38, Lordship.
Yes,
38.
13 August 2014. Lordship.
This is not the recommendation of the SLC. How can you say this is the
Lordship, the
recommendation?
recommendation is 37. Lordship.
37.
Recommendation sheet for appointment of commission and gown, Lordship. The total post.
Okay. I'm directed to send you the list of candidates for appointment and compassionate grounds, comparison, so and so, so and so, so and so, so and so.
49 is the-
So this is a compilation made for the SLC to be placed before the SLC.
Lordship, have a look at page 49. CL number 97. Deepjyoti Boyso, General, task recommendation for appointment against vacancy of grade 3 post
Page 40.
49. Repeat the recommendation of SLC. Lordship.
Serial number?
Serial number 97. Deepjyoti Boyso, General, Caste General, date of application 7/13/2004, date of birth of the applicant 1st March 1982, higher secondary Lordship, education qualification 29 January 2004, recommended for appointment. against the
Mr.
vacancy.
Show me that this is SLC.
So this is the 13 August 2014 Lordship, page 38.
Wait, just a moment. You just have your instructions. We'll take it on day after. Just have your instruction whether this is page 38 onwards is SSL minutes or a placement before the SLC.
Okay.
And then what was the consequential minutes?
Okay.
Just get it to me on Wednesday. Mr. I. Bhattakar, Learned Counsel appearing for the Forest Department, submits that he be given a date time to receive instruction as regards the claim of the petitioner hearing that his case for appointment on compassionate grounds were recommended by the state
SLC
level
state
scrutiny
30.
committee in its meeting held on
13/8/2014.
13 8 2014. Now come back to page 33A.
That is the number dated so and so.
Your name is here.
Lordship, my name is here, Lordship. Page 49.
No. What is this page 33A?
Lordship, page number?
33A.
Here my name is not there, Lordship. This is the address appointment.
So,
That we come here, Lordship.
okay.
And
Okay. So this is the appointment order issued. Page 33A.
Some has been appointed, Lordship.
2003 vacancy also done. 2003 also, Sondrama Dotto, Miju, Borali, Manjula Sil, so and so, Gogoi, and Dibyojyoti Gogoi. So
Only
after these recommendations,
he has been appointed.
Mr. Counsel, after these recommendations, this is the appointment. Your name is not there.
So I post this, Lordship.
So this is recommended by SLC. So this is not recommendation of SLC.
Also, let them file the affidavit, Lordship.
Huh? Why? Why?
Because same SLC are already coordinated.
This is, SLC is not a conservator of forest, Mr. Counsel.
Lordship, available page 72, Lordship. His name also not there. In Noyanguti Deka. The Honorable Court directed them to appoint Lordship. 72 the read petition.
Maybe the court was misled. We'll want to clarify, get that clarification. Both on page 33A, appointment, whether that is preceded by what and what is the purport of this page 38. Feelings, Mr. I. Bothakur. Two 2014
13/8/2014.
also. List this matter again on Friday.
Friday.
Friday only, Deuteronomy 2/8/2015.
Obliged.
Obliged.
Advertisement was made on 28/11/2022 for collection and appointment of Anganwadi worker.
Have the respondents filed their affidavits, Mr. Bring it on record. Or you want to have some better instructions?
Let them obtain instruction as to what is the percentage of mark.
Yes, Mr. Chaudhary.
Lordship, I have not received the instruction, Lordship. I have already.
On the prayer of Mr. B. Chaudhary, Learned Counsel for the petition. For the respondent, BTC, Standing Council BTC, registered to list this matter again on 14/8/2024. Mr. Chaudhary shall receive instructions and place the same before this court on the next date of listing.
May I please, Your Lordship? In this matter, I was appointed on compassionate ground, Your Lordship, but not regularized. I was appointed as a work charge employee, Your Lordship. A lot of affidavit has been filed by the respondent, and wherein it is admitted that I was appointed on compassionate ground.
Yes.
Lordship, I have filed my affidavit on last month. If he is not filing any reply, Lordship, then Lordship will hear this matter. This matter have some implications, Lordship. Let him file his reply.
You also admit that he was appointed on compassionate grounds.
The undersecretary.
So compassionate ground appointment cannot be against a ad hoc post.
Lordship, one approval is there by the undersecretary. And what kind of approval it was, what
Forget
were
it.
the considerations?
You had
of
made
that
a
one?
statement in the affidavit
Yes.
that his appointment as a work judge was not. But if he is deemed to be entitled for appointment on compassionate grounds, that's the end of the matter. He should be.
Under the scheme, Lordship, it is a regular post, sanctioned post.
So how can you make an appointment beyond this scheme?
No, Lordship, suppose Lordship, there are examples that are concerned with
That is neither here nor
issued
there.
appointment letter just by setting the words phrase compassionate appointment.
That you have not said, that you have not taken a plea in that affidavit. You say his appointment is on compassionate. And
That because
give him
that
the
approval
full
of the-
benefits.
So let him file one reply, Lord.
No need. Why? If this is supporting him, why should he go and unnecessarily file? Appointed as so-and-so on compassionate grounds on 7/7/93.
The appointment letter is there.
Where is the appointment letter?
Your Lordship, the typed copy is at page 25.
Page 22, Mr.
For your Lordship.
Nayak.
Lordship. Yes, I have seen that.
So
approval is there.
So that appointment by the executive engineer was wrong. This is the first time you have come up before this court.
Yes, your Lordship.
So we will ask the appointment to be deemed to be a regular one. Notionally fix your pay in the now. You are getting a pay, I suppose, in the work charge post. You're getting a pay in the work charge post.
Yes, your Lordship.
Pay scale. So
Yes, yes.
financially, there will be not much difference.
No.
So treat him to be a regular employee from that day. Pension, pensionary benefits, whatever is the release. Yes, Mr. Borpujari, anything?
Appointment letter is at page 14. Lordship has seen it. No, my lord, there is no approval of the government as such, so far as page 14 is concerned.
Have you made a statement in the affidavit? Affidavit, you said it is an appointment on compassionate grounds.
It is an appointment, then my lord, the question will fall, my lord, whether
If it is an appointment on compassionate grounds, there is no question afterwards.
No, my lord, I will be raising an argument under Upendas, my lord, they come in Upendas. Because
Sorry,
No,
we will reject it, test it.
Lordship will kindly hear me, my lord, because that will relate to my lord against a sanctioned vacant post. Now that aspect of the matter, my lord, the materials are silent. Whether that appointment was against a sanctioned vacant post. If it is against a sanctioned vacant post, my lord, I have nothing to argue, my lord. But if it is not against
No, if you have appointed him against a work charge post, you made the error.
maybe
He
my
should
lord,
have been appointed against a regular sanction post.
absolutely, but having not done so, my lord. rightly
Having
or-
not done so, you can't take an advantage.
No, my lord, I will be taking a cue, my lord, from Upendas, my lord, because Upendas is categorical, my lord. Hello.
Sorry, reject it. Check it, test it.
Then Lordship may kindly parrots this decision, my lord, the coordinate bench, my lord, a very recent one. Because if the parameters, my lord, set forth in Umha Devi as well as Upendas, those are, my lord, satisfied.
Tell me one thing, is the petitioner involved here in also a compassionate appointee?
No, he was not in a compassionate appointment, but that aspect of the matter that my lord regular sanction vacant post. And one order passed by the division bench that lordship will kindly find it, my lord, towards the end of that decision, my lord. One order passed by the division bench whereby, my lord, a claim was sought to be made, my lord, for regularization of service. Then, my lord, the honorable division bench, my lord, had passed a dictum, my lord, in a missed case. Lordship will find it somewhere there, my lord. In a missed case. In a missed case, there was a, my lord.
In this case only?
In that case, in that decision, which is just before your, my lord. There's a reference of a missed case being filed by the state, seeking the permission of this honorable court to go for regularization. Then the division bench of this honorable court says, if the policy doesn't, my lord.
No, I'm not on that. Is that miscase in connection with a compassionate appointee? Right. Heard the learned counsel, yeah, your name?
Mr. A. Khan.
A. Khan, learned counsel for the petitioner, also heard Mr. R. You're appearing for purposely for?
My lord, for the finance department, my lord, respondent number 6.
For the respondent number 6. Also heard Mr. P. Naik, learned standing counsel, PWD, appearing for the respondent number 1 to 5, and R. Pujari, respondent number 6. The list this matter again on Wednesday for delivery of orders.
Obliged, the lordship.
Madam. Mr. Barpuzari, I remember. That's why I just kept my hands tight. There is a decision of the Supreme Court covering the issue. And I think I have delivered one order on that also.
I will be checking it, my lord.
Do it. There is an order. There is a decision. I'll collect it, then apply that, and then pass the order on Wednesday.
With all sincerity, my lord, we only make attempt, my lord, to persuade, my lord. I'm so obliged.
I would love it if it is with some meat.
I just cannot overcome it, man. Anyway, I'm so obliged.
Yes.
May I please, the question?
Hmm.
Also, this matter has a checkered history. What has happened on the last?
What is to be done today?
No, my lord, I have informed my friend also, my lord. Just, my lord, the issue here is, my lord, now, because of the bifurcation of this WPDBC department, now these two nodal departments are not a party in this case. The tribal affairs and social justice, my lord. He has to make them a party, my lord, so that some instruction can come. Any effective order, even, my lord, the court has to pass, my lord. These two departments has to be implemented, my lord. Without them, my lord, it will be a little difficult, my lord.
Yes, what is your grievance?
My grievance is that, lordship, these petitioners, this set of petitioners were appointed in 1983. Wherein they, the time when they were appointed, the government came up and said there is co-terminus with the advisory bodies. Then we came before this court. Court held that though the tenure of the chairman and other things were co-terminus, their appointments are, lordship will kindly take up page.
My lord, Justice Roy's order.
And subsequently division bench, upheld by the division bench, page 45, last part. Division bench order. If I may read it slowly, your lordship.
No, it's okay.
The learned single judge has made a detailed assessment of the situation.
Then what happened?
Yes, lordship. Now my grievance is that I've been appointed, but they are paying me fixed pay. They are not giving me the grade to which I am entitled to, and the arrear pay for this the petition has been filed. My prayer is to the effect that from the date of when I have been appointed, I should be given the arrear pay and the grade pay. That is my case.
Show me your initial appointment order.
Yes, Your Lordship. Annexure 1. Lordship will find it at page 20.
So initially they gave you a scale of pay.
Yes, Lordship. Yes, that is the thing. Middle part.
How were you recruited? What is the modality of recruitment preceding this order?
Lordship, call for applications we have given.
Where have you stated so?
This on the earlier petitions, this point was taken up, and there it has
Been settled by this?
yes, it has
Where?
been finally.
Where?
That point of appointment, yes.
So where is that finding?
Lordship, page 47. Division bench judgment. It is for this reason that the direction was issued to respondent to treat them as permanent staff of the concerned council.
Where are you reading?
Page 47, Lord. Page 47 of my writ petition.
The reasoning given, that's the last page of the division bench order.
Yes, sir.
Reasoning given was that though the appointment so and so may be political, but the post held by the so and so are permanent in nature, therefore their being in service only till such time when is so and so. It is for this reason direction was issued to treat them as permanent staff of the concerned council.
That is how, Lordship. Lordship, may take up page 48 after that. The order. After the division bench order.
So you come to page 48.
Yes,
This
sir.
order,
Yes, annexure 4, Lordship.
this is what your grievance is now.
Yes, yes.
Huh? This is issued by the Department of Tribal Affairs, plain. You have not made that authority a party. That's your grievance.
And further, my lord, social justice also has to be made a party. Because they are by.
So you take steps, make them parties, we consider. But the learned counsel for the party, Mr. K. Monto, learned counsel appearing for the petitioners and also Mr. R. Learned counsel appearing for the respondents number 1 and 2. Also heard Ms. S. Swami. G. Swami. Learned counsel appearing for the respondent number 3. Also, Mr. K. Monto submits that he be given a week's time to file appropriate application for including the Department of Tribal Affairs, right?
Yes, my lord, tribal affairs, plain.
Bracketed plain as a party respondent in the
And my lord,
present
social justice
proceeding,
empowerment.
along with the Department of Social Justice and Empowerment, Government of Assam. Prayer accepted, raised to list this matter again after 10 days on a date to be fixed.
Please, Your Honor.
Bill to give, bill is an bill of us. Dhanasda boy is a bill to give. Mr. D. Das, you are sitting for the bill. Oh. It just missed my notice, or we could have taken up it earlier also. Yes, we'll take up the bill. Bill. Yes, what is this?
Yes,
Why
sir,
is it before me?
Previous bail application, madam. FIR, my lord, is at page number 11. The allegation is that some 19 buffaloes, madam.
Oh, that case.
Yes, allegedly stolen from.
Why is it? Because there was a similar matter pending. No, only this.
One matter has already been disposed of.
Disposed of by?
Yes. On 11/7/2024.
Yes, Mr. Das, you have got the case there. What is it? Nothing.
The purchaser has been caught and he purchased about 16 buffaloes, stolen buffaloes, at the rate of 60,000 per pair. A couple of buffaloes. And he paid 1,80,000 rupees to this petitioner. So basically, that is the allegation. So he sold the cows, buffaloes.
Is this custodial interrogation required for that? Heard Mr.
Yes, that's fine.
S. Das, learned counsel for the petitioner. Also heard Mr. D. Das, learned additional public prosecutor appearing for the state. What's up?
Subsequently, these robbed buffaloes were recovered. Some buffaloes from the purchaser and some in abandoned condition.
Okay.
And all are handed over to the person.
The petitioner hearing. You are not a named accused.
I am the
Yes,
number 1.
was
The allegation is that I am the driver.
the one Jalaluddin lodged an FIR before with the police of Borghat police outpost, alleging therein that the petitioner hearing, along with 2 others, stolen away buffaloes being brought in a truck on 15/6/2024 after tying the arms of the informant and others therein. Also, the police on receipt of the said FIR had registered a case being Borgat, being Tezpur PS case number 356/24 under section 395/411 IPC, read with section 11 of the Prevention of Cruelty to Animals Act and section 13(1) of the Assam Cattle Prevention Act. Also, this court had, while order dated 12/7/2024, direct the additional PP appearing in the matter to produce the case diary. The case diary of the above noted police case has been produced by Mr. D. Das. Also, this court has perused the said case diary and it is revealed that the buffaloes purportedly stolen have been so recovered along with the have been recovered. Full stop. In that view of the matter, this court is of the considered view that no further custodial interrogation would be called for of the petitioner hearing, and accordingly, this court is pleased to
Custodial interrogation.
anticipate.
There are also some other people also involved with him, So custodial interrogation will be required, because others are absconding. There are other allegations, robbing of 2 lakhs rupees.
But in that case,
and
my lord, my
gold sale.
submission will be, my lord, let him appear, my lord, let him participate, then.
My objection will be recorded.
We will ask him to appear before you. Custodial interrogation would not be called for. Accordingly, this court is pleased to enlarge the petitioner hearing on pre-arrest bail of rupees 30,000 with like surety, with a like surety of equal amount to the satisfaction of the Chief Judicial Magistrate,
CJM.
Mr. Das, CJM.
CJM.
Tezpur. Full stop. Subject to the following condition. 1. The petitioner hearing shall within 7 days from today appear before the investigating officer of Tezpur PS case number 356/24 and have his statements recorded therein, and thereafter the petitioner shall continue to appear before the investigating officer as and when called for. So, Baki kita normal condition shall not hamper temper. With the above observations, the anticipatory blame application stands disposed of. I've got the main property back. What is there now? The other person has also been released on bail. I'm not.
Yes. That I do not.
They are accused to, he has made a statement.
Since this is my inaugural appearance before your lordship,
I should say welcome. Oh. Itu maju. Same, itu maju. Mulai order itu. Itu amount to 30 कोटी को बाकी same my order only.
That is why it is listed before your lordship.
I was shocked why it has come to me. I was really taken aback. Anyway, admission to continue.
May it be the last. Manoj,
Yes.
The government was directed to obtain stuff. Lordship, as it was a 6-2 suspension, Lordship.
6-2 suspension also from the date he is released 90 days.
Yes, Lordship.
Then what is
The
more?
only issue, only the instruction required to be obtained was whether any search.
If there is no instructions produced, we will record. We'll draw a presumption there is no departmental proceeding done.
No, my submission on last date was that as we are not drawing any departmental proceeding, Lordship, it says 6-2 suspension. So let the police obtain the instruction whether any search sheet has been filed in the criminal case or not.
And that already done for on 22/7, this court had required. Yes,
Lordship, on last occasion, I have been asked, Lordship, I have written the authority, but no specific instruction on that particular.
oh,
point.
who is the authority to give you that instruction?
Lordship, I.
We'll ask him to come here.
Okay, Lordship, then day after tomorrow.
That is more acceptable. Ms. M. Bachaji, Learned Counsel, Government Advocate, Senior Government, Additional Government, Senior Government Advocate, submits that she be given a day's time to receive instructions as to whether any charge sheet has been filed in the police criminal case so instituted against the petitioner hearing. So accordingly, registry to list this matter again on 29, 30, 31.
I'm obliged, Lordship.
Just get that instruction, miss. That's enough. Finish.
Lordship, obliged, Lordship.
Obliged, Lordship.
Mr. Hey, review to you.
My lord, I'm not agreed by the judgment passed by your lordships.
No,
I just.
I'm on a different footing altogether. See, a review can be maintained if it was something which was not there on records on the day when the order was passed and discovery made subsequently.
Right.
But in the affidavit that was filed by the authorities, they have brought on record the subsequent select list. Sorry, not select list, but the list
It's for approval. Yes.
for interview. And therein your name was omitted.
Also
That was very much
apart
on
from
record.
that, my lord, I want to file a affidavit because, my lord, there is certain allegation directly to me, my lord. So that I cannot, my lord, tolerate. I will file an affidavit on that point, my lord. Because your lordship kindly see our innocence.
We are there, Mr. Monto.
Sometimes, my lord, our innocence has been not been counted by the petitioner as well by the advocate.
No, please.
The copy has been served to them, my lord. Even a request, not only one, twice.
Mr. Monto.
My lord,
So that I have to reply.
I was never given.
Yes, I
Mr. Monto. What is the first question this court asked?
My lord. Yes, I don't. But that is well in record, but I also serve a copy to them, my lord.
I will satisfy your lordships. I don't know whom he has given. It was never given.
Hey,
to us.
record to call karo.
My lord, we can find.
Where you have the
affidavit to
record,
that
records here. The records of that case.
Well, we never make any allegation without anything on record. And your lordship kindly see. I'll take your.
My lord, I again.
Mr.
It was asked personally
Doctor,
to me, I have given copy to
Mr.
them.
Doctor, there is no issue. Maybe if your name has been left out in a manner not called for, we are always there. But in this fact situation, once that material was on record, right, you were participating in the proceedings. It was your duty to point out.
No, that occasion.
That occasion you should have.
No, my lord,
Because why I am saying so?
Yes.
Because it was you who were the loser. Because that issue was never a issue before this court.
Yes, my lord, when I got to know from my lord this situation, that is only on.
And you have not made a statement in the review petition that you were not served with that affidavit.
My lord, one thing I'm.
Have you made a statement?
My lord, what?
No, have you made a statement somewhere?
Your lordship kindly see, read the judgment.
I'll go through that.
1982
Have you
Supreme
made a statement in the writ petition, in the review petition?
Yes, it is.
Where is that you were not given a copy of that?
Before that, my lord, how the review is maintainable, your lordship kindly have a look in 1982 Supreme Court.
Mr. Doctor, there is no issue on that.
Para 4.
There is no issue on that. But I want certain clarifications. Where is your statement in the writ petition that the affidavit filed by APSC, you had no
Yes,
access?
yes, I think we have stated. Last minute statement. Just 2 minutes, Your Lordship.
I have found one statement in para 24, second paragraph.
You stated somewhere. Your Lordship.
Rather, it's very categorical.
Melody, Your Lordship may kindly see at page 26, para 8. That the review petitioner begs to state that in order to ascertain the cause behind non-inclusion of his name in the list dated so-and-so published by the APSC, he had again approached his counsel representing him before the Honorable Court. On being so approached, the counsel for the review petitioner had again meticulously gone through the judgment dated so-and-so, but did not find any reason or exclusion of the name.
Because I still remember that affidavit was in many times referred to me.
My lord, they never argued.
You come to
15
para.
No, my lord, directly they have nowhere stated. But Asostha Mahato Intuiti Gozo, that line,
Why
so
are
what you
the-
kindly say.
because
That's
Mr.
why normally I am not agitated, my lord, in this type of matter.
Mr.
But it is, my lord, it hurt me. That's why, my
I
lord, because
understand.
I know personally.
I
what
know.
Then they have done in that day.
Mr. Monta,
No, I will not, I'll file personally if it is required.
you,
Well, I am ready. Because I have nothing to hide, my lord.
you just have your seat.
We are also ready to file our affidavit.
Because in his special request,
Both
he
of
made
you
and I have given to him.
both of you are going tangentially. What am I doing here? Kindly answer to my queries, Mr. Doctor. Mr. Monta,
My lord.
please.
I'm sorry, my lord, because it
I
hurt me, my lord, that's why.
understand your point. I have also noted in the
Because
petition.
33-year practice, my lord, I am. My lord, I never.
Mr. Monta, did this court,
His personal request,
Mr. Monta, did this court ask the counsel for the petitioner any other question other than that? Why do you think we have asked for that specific question? Because we found materials,
My lord.
allegations.
Yes.
Because I personally remember that matter, the arguments that were advanced.
My lord, on that day, your lordship found the 43 ineligible candidates.
No, for the
Not
for the
58.
purpose of review,
If we include 15
see,
ineligible.
Mr. Doctor, you have been now for XYZ reason said to be not eligible. Right?
No, so
For
therefore-
XYZ reason, you
therefore, your lordship,
Mr.
give me a
Counsel,
chance so that I can explain.
I'll let me get out my queries. You have been held to be not eligible. For whatever reason it may be.
Yes, yes.
In that judgment itself, I have provided for that after the conclusion of the process, on getting the materials, you are entitled to come back.
Now
But we will not entertain this review, neither the petition.
Now the question is whether we are informed that we are ineligible.
It need not be. That was there. That was a
Then
public
that-
notice made.
when
No,
it
that
was-
was a public notice made.
No, your lordship.
Affidavit,
kindly see-
get the affidavit. It's on record somewhere I saw.
Your lordship kindly see read petition 3505. The advertisement dated 25/5.
You can come straight to the affidavit at page 80.
Yes, that I have seen, and I am explaining that, my lord, what happened on that day.
And you have not disclosed from where you have procured this copy.
Yes, yes, that I have said, I have.
You have
collected-
somehow with
somehow I
difficulty
collected.
procured. From where?
It was never given to us.
Okay, from where did you get it?
Now therefore, whether your lordship can.
Mr. Doctor, you will have to satisfy this court from where you got it.
Yes, yes, that I.
You have not said, you have somehow difficulty will not be do.
That I will explain how we have got.
You come here, this is there
Now I-
at page 128.
Yes, 128.
128, your name should be in serial number 1.
128, yes.
Your name should be in serial number 1. It's not there.
Now, this is
So
an
in my
excess-
order, I have categorically made one condition following that Supreme Court decision that information would be revealed only after the conclusion of this election process.
Yes.
You can come to para 37.
There are 37 of the read petition.
Similarly, people like you are also covered by this. Before parting with the records, page 64 of the review petition. Before parting with the records of the case, this court would like to observe that the petitioners herein having not been granted access to the marks secured by them, and also the 2 petitioners who were found to be ineligible to participate, so and so on account of their educational qualification processed by them, being not permitted to raise the issue in the present proceeding, liberty is reserved to all the petitioners to raise objections in the matter with the authorities of the Assam Public Service Commission, and also to approach this court by way of filing appropriate application, raising any grievance pertaining to the matter in which their cases were so considered. After the selection process is complete and the information documents pertaining to their performance qualification are provided to them by the Assam Public Service Commission. So why should we, in your case, make a detour?
Now, your lordship, I'm taking your lordship's to paragraph 6, 7, 15, 16, 17, 18, 20, 23, and 26.
Okay.
And I'll show how whether these 15 ineligible candidates were ever argued before your lordship.
It was not an issue because they were not here. You were here, you did not point out.
No, my lord. The question is this, we're not given a copy.
Okay,
We
let
do
us assume Mr. Mohanto has suppressed all requisite facts.
The question of suppression is
Oh,
not
Mr.
there.
Mohanto means the APSC, suppressed. It boils down to the fact that your candidature was rejected.
No, before that, your lordship kindly see whether these facts were.
I
adopted
could
in
not,
any point
even
of
if
time.
that facts were placed before me, I would not have entertained that, because that is why in the last paragraph, I have made that observation.
But then question
That will
was-
apply on
I
all
think-
fours to you also.
I take your lordship to these paragraphs, and from where it is clear that these 15 ineligible candidates.
I'll clarify
were
that.
never-
I'll clarify that.
Yes.
I'll clarify
Now,
that.
your
Mr.
lordship kindly come to page 49, para 6 onward.
This was writ petition number
My lord, I am.
6005/2020.
Yes.
Apuni, a writ petition to records to call for 005/2021. এইটো ফাইল আপোনাৰ তাত থব ৰেকৰ্ডটো আজিয়ে কল কৰক দিও
In fact, my lord, another petition filed after me during vacation, my lord, he was allowed to sit in the examination.
I've
also.
seen that. We will consider, no problem. But I'm on the review only. It will call for Ajil Veha, Moporo, fix creation. Mr. Doctor, we'll call for the original records
My lord,
of 6005 and then we will consider
after calling the entire.
records. We'll have it on Wednesday.
Um,
Or on Thursday, it will be a bit
No,
more,
madam,
matters will be less.
Judgment which I have given.
82.
That paragraph 4, my lord.
What is it?
My lord,
The power of review comes from that paragraph. only.
Written, it will do.
my lord, can it be in next week, this week?
Whenever it's convenient to you.
Next week, my lord, I am totally because. I have
ILI,
function. Yes. sir, I have
ILI,
function.
Supreme Court, you know.
My lord, this week, a little bit. If your lordship, my lord, permit, I can file a affidavit also.
But no need. Mr.
No,
Doctor
my-
has not made those statements with that intention. Don't
No,
do
no,
that.
it hurt me.
He never will make that intention.
Because
You get my Mr. Montop? Rest assured, on behalf of Mr. Doctor, I am making that statement to you. But we will examine, don't worry.
My lord.
And if we find, I'm telling you, subject to Mr. Doctor satisfying me, even if we find that that aspect was not considered by this court, we will consider it in the review jurisdiction. But we will conclude that any grievance of his in that direction would be in terms of my last 2 paragraphs of the
My lord.
My lord, I can tell you lordships, my learned friend should not be agitated.
Mr.
I
Dr.
hold-
Fogel, leave it.
I hold him with much high esteem.
Mr.
I
Doctor,
have much impression
Mr.
on him.
Doctor, maybe you have kept your ears closed. I think you must have heard what I told Mr. Dotto, Mr. Monto about you. And after that, is there something left? Then had the Learner Council for the parties review memorandum list this matter again on when, Mr. Monto, when?
Next week, my lord.
Any, you give me a
Will
date.
accept 5th and 6th August.
5th and 6th. Maybe
My lord.
Arunachal,
No, Calcutta.
Calcutta.
9th, my lord.
9th, done.
Obliged.
Let it, can it be on 8th? 9th is Friday, we don't know how it will be.
Okay, no problem.
8th, 8/8/2024. Registry to tag the records of WPC number 6005/2021 along with this review petition. So, tag korabo koishu kintu apni ani thoi dibo. Ei file kita pothabo nalage 22 tarik pothai dibo. Mok di dibo.
The lordship is called the record.
We have called for the records. We'll
Okay.
get the records today. Mr. Monto,
My lord.
on 8th, we will consider.
Obliged.
So on that day, nothing of this sort of arguments.
No,
This is
It's not-
end today.
it's not required at all.
You can have a cup of tea outside, but we have ended all those. Now only on the merit we'll go.
Yes.
Develop.
Wait, please, Your Lordship.
Yes, madam.
Lordship, as per last order, we were supposed to take steps on.
You have not taken steps. So we are saying that enough. This is enough.
Lordship, we have informed the petitioners.
Okay. Heard the Learner Council for the petitioner. And also the Learner Council, Mr. I. Botago, Learner Council appearing for the respondents, right?
Forest Department. Lordship.
Forest Department. So, this code on the Laojima Court, while an order dated 7/6/2024 had required the petitioner to take fresh steps for service of notice upon respond number 3, 4, 5, 6, and 7. So, however, the said steps not being taken, the matter was listed before this court on 26/6/2024, wherein this court had further granted extension to the petitioners to take the requisite steps within 19/7/2024. It is said, that in spite of such leaving granted to the petitioners hearing, the steps have not been taken upon the private respondents. Prior steps been taken for issuance of notice upon the private respondent. Also, Miss Learner Council, you are appearing for?
I'm appearing in the matter, item number 50, Lordship.
That is connected.
Yes. For the petition.
Same issue.
I seek apology for that.
Huh?
I seek apology for that. Lordship, steps are supposed to be taken, Lordship.
You have also not taken in your 50 also.
Lordship, there are a lot of respondents and we have.
We are closing the matter. We are not considering this further. We are dismissing it.
Lordship.
Or if you want me to adjourn it, cost. This court will not. Choice is yours. Dismissal or cost. I'm with you. Either way.
Lordship, I seek apology for that. and
Your
one
apology
last-
accepted with all due benefits, but my order is violated. I can't help that. If your petitioners are not interested, that is the end of the matter. Why should we carry these files? Dismissal or cost? Decide within 10 minutes. We'll proceed with other matters. 10 minutes, we'll. 10 minutes, Bishop. Those days, this not taking steps, leaving it like this, we will not tolerate.
Well, Lordship will have a look at the last order. Well, in this case, I'm there to assist the petitioner in person, my lord, and appointed as an Amica registrar.
Yes.
Yes, Lordship, here the remaining non-pay practicing allowance amount that
Is the only the non-practicing allowance left now? What are the components left?
Non-practicing allowance that has been paid.
Paid. Okay, what
My
is
lord,
left now?
Only thing Lordship will see, that last order 26/6/2024. Now they have stated that a sanction of rupees so and so has been sanctioned for payment of petition in person towards arrears salary from 1/1/97 to 6/1/98. In fact, this is for 1/7/97 to 6/1/98. It ought to have been 1/7/98 to July 1998. 97. So out of this 13 months, they have given a portion.
How much?
This amount is 1,09,328. The order says that it is for the period 1/1/97.
Okay, take me to the original order, violation of which?
No.
Yes, Lordship, page 17, Lordship, of the contempt petition. Page 17, Lordship, point 1 and 2, Lordship. Lordship, we have made all the payments over here.
Now, the second direction, the petition person submitted that he has not been receiving his area salary as well as non-practicing allowance.
So according to the petitioner, area salaries is due from when to when?
July 97 to July 1998. That your lordship will also find reflected in an order passed in this proceeding on 8/4/2020.
8/4/2020. You can have your seat.
Where the containers were directed to file an affidavit.
Lordship, here, let me.
Please, let me-
No, I'll also speak. Allow me to speak also.
So.
Mr. Cholia.
Lordship.
Area salaries.
Mr. Cholia.
Lordship.
When your turn would come, we will definitely hear you. Why don't you have your seat?
So, my lord, the area salary is from July 1997 to July 1998. And the sanction memorandum for this amount of 1,09,328 that was issued on 24/6 is for 1st of July to 6th January 1998.
And your grievance with regard to the
July.
No, your
97
grievance with regard to non-practicing
That
allowance.
has been written.
So now it is only the
Only
area,
that.
only area.
Area?
Yes, Mr. Solia.
Yes, Lordship.
You
here-
have in the order dated, your statement in order dated 8/4/24 has been recorded
Lordship.
that he is entitled to 13 months of salary.
Yes, Lordship.
So that is from July 97 to July 1998,
Lordship.
right?
This is the sanction memorandum. Lordship will see that this amount of 1,09,328 is from 1/7/97 to 6/1/98.
Mr.
Yes.
Take your seat. So your submission is that this is amount is from 1 July 97 to 1/7/98.
Lordship.
Now, great thing, you have thereafter released to the petitioner some money. That is from 1/7/97 to 6/1/98.
Yes, Lordship.
So what would now be there for the next 6 months?
6 months. Lordship.
Roundabout.
Lordship, yes. That 6 months amount, Lordship, I'll have to go and confirm. Lordship,
Why?
here, what
You
has,
have already confirmed.
no, Lordship, here, what has happened is, Lordship, an amount of 82 lakhs has already been paid to the.
Forget, we are not worried.
Yes.
We are not worried with the quantum. We
Lordship,
are worried with the period.
here, Lordship, then.
A
the-
man is we have seen him
Yes.
for a long time.
Yes.
Now, your statement is that his dues are from July 97 to
No.
July
No,
98.
Lordship, here, he had produced a document where he had claimed
Forget
that
it.
this was missing.
This is now recorded,
Yes.
13 months.
Lordship.
So you have paid for around 1/1/97 to 6/1/98. Right?
1/1/97. Lordship, I'm just getting the calculation, right? I'm not, 1/1.
97 to 6/1/98 you have paid.
6/1/98.
You have paid. So from 7/1/98 to 1 27/1998.
That is 6 months time, Lordship.
So roundabout.
Yes, that is.
So compute that, pay him.
Lordship, yes.
We are giving you 10 days time.
Lordship, yes.
On the next date, the compliance
Lordship,
report
yes.
be placed.
Otherwise everything else, Lordship.
No, no, no. This one. Then only we can say it is complied with.
Lordship, yes, that we're
Mr.
not disputing it.
Mr.
Dr.
Loskar. Dr. Loskar, you have no other grievance other than the 6 months salary?
See, there is. Lordship, the amount which was promised to be paid in the last hearing was 1,09,328. They have paid to me in my account 1,08,213, 1,000 less.
They have paid 1 lakh.
8,213, and that is my.
108230, right?
108,213.
8213. Out of 109328.
This is my SBI account number.
We believe you. That much will do. Your oral submission is enough for this good. So you say there is a reduction in the amount that was sanctioned and what was finally deposited. So we are not drawing any inference. There might be some deduction somewhere.
Yes.
So maybe that is done. That Mr. Cholia will clear. Then you have this period of 6 months, your salaries. So he will take instructions. If it's due to you, within 10 days, they will make that payments and a compliance report will be submitted before this court. 15 days.
Right. We have made the payments, Lordship. There were certain discrepancies in between.
You clarify it.
Yes.
Mr. Chalia, heard Mr. S. Chakraborty, learned counsel for the petitioner, along who appears as an amicus in the matter. Full stop. Also heard the petitioner in person. Full stop. Mr. A. Chalia, learned counsel for the respondents, has submitted that out of the areas due to the petitioner on account of out of the amounts due to the petitioner on account of his area salary for the period from 1/7/1997 to 1/7/1998, the respondent authorities have already made payments for the period from 1/1/97 to 6/1/98 and an amount of rupees 1,09,328 was sanctioned for the purpose, which is contended to have been credited to the account of the petitioner. However, the amicus curiae appearing in the matter has on instruction submitted that the amount credited to the petitioner's account was only 1,0,8,230. 213, sorry, 1,08213. So, Mr. On consideration of the above submissions that are advanced by the parties, it is seen that the salaries of the petitioner from 7/1/98 to 1/7/98 is still not clear. So accordingly, Mr. Chalia is required to accordingly, the respondents are hereby directed to compute the amount due to the petitioner as areas of his salary for the period from 7/1/98 to 1/7/1998 and to release it to the petitioner within a period of 15 days from today. Mr. Chalia shall also receive instructions as to why there was a reduction in the amount deposited in the account of the petitioner on account of area salaries for the period from 1/1/97 to 6/1/1998. List this matter again on on 12/8. Would it be fine? 12/8/2024. Mr. Dr. Loskar, if you have any problem in coming, you can always ask for a VC link.
My lord, there's some correction, my lord. Instead of 1/7, it should be 31/7 because the July ends with 31 of July.
Let it be like that.
Lordship will clarify.
In that order, otherwise.
Lordship, this is They are
No, no,
dictating
I'm
the
not,
dates.
there is a
Lordship.
recording made.
Yes,
So
they-
let it be that, let,
Lordship,
if
we are
there is,
paying the amount, Lordship.
if there is 30 days, we'll do that. Don't worry. Mr. Chalia is ready to give you, why are
Lordship,
you?
we have been
You give him
complying
some time.
since day
Mr.
one.
Chalia,
with-
get the thing clear of.
Here in this case, I don't know any hint. I have been
No, no, no.
appointed.
It's good thing that you are assisting him because he's been behind this for a long time.
Yes,
So he should get his full relief. He should be satisfied
yes.
that this court has given him the full relief. That's it. We'll ensure that.
Lordship.
Hmm.
Okay. This matter is ready for hearing. Record is available. Rule already issued.
Raised it to list this, first of Mr. Learned Counsel for the parties have submitted that the pleadings in the matter is complete. Accordingly, the same can be taken up for final, for hearing. Accordingly, registry is directed to list this matter for hearing in the month of September 2024.
A fixed date may be given.
Huh?
Fixed date may be given. Punishment,
New matters, old matters you ask me, I'll give you. New matters,
what is the punishment of dismissals?
we'll see. That's why you have made a challenge to that. We'll see.
Already.
Mr. Chaudhary, Mr. Photogi, we have seen it. We'll just issue a notice. We'll on the next date, we'll say. I think I made a error. What I said I'll do, I did not do. So we'll have to rectify that, but that will not materially change the order.
No, yes, Lordship, 46C is there, Lordship.
So you can always proceed. Just issue a notice. Heard Mr. S. Kotogi, Learned Counsel for the petitioner. Also heard Mr. J. K. Goswami, Standing Counsel, Assam Cooperative Apex Bank Limited. Issue notice. Returnable 2 weeks. 2 weeks. Also, Mr. Goswami accepts notice on behalf of all the respondents. Also, registry to list this matter again on completion, immediately on completion of 2 weeks from today.
Today the matter has been fixed for final disposal, my lord.
A few minutes.
My lord,
back,
we have
government has,
filed an
copy of
affidavit.
the affidavit on us, your lordship.
We filed an affidavit in opposition today, my lord,
Why?
for respondent numbers 1 to
Why?
5.
Why? After the matter was fixed for final disposal, why have you filed the affidavit?
My lord, we had not received the vetted copy, my lord. We received the copy only today in the morning.
Just a moment, just a moment, just.
Lordship will receive the last order. Last order.
There is an IA.
My lord, it is there, my IA, my lord, item number 56 for stay vacating.
I was considered long back, your lordship.
Oh,
It has not been considered, my lord.
be that as it may. I had fixed this matter for final
Yes, your
consideration.
lordship.
But
Because on
now,
this occasion, we paid for time for filing affidavit in reply.
now,
Now they have.
My lord,
served
what I'll
copy.
pray before lordship, my lord, since they have filing affidavit today,
already filed.
already filed, I have not received copy, my lord. So let them supply copy and lordship fix the matter, my
You
lord.
only
and
serve to the petitioner, you don't serve to your colleague respondents also.
Is affecting me, my lord.
My lord, I'll make-
Today,
Yes, my lord, now it's
Ms. Bhuya, how long will it take you?
At least 4 weeks time, your lordship.
Why?
My client,
My
client
lord,
is
they are
from Buxar.
ending stay, my lord. Lordship fix
Lordship,
the day, my lord, stay vacating column, my lord.
Stay
Any day
vacating
next
was
week.
considered in the earlier writ petition, my lord. This court, honorable court was pleased not to vacate
My
the
case is
interim
still
order.
pending, my lord.
Same, Ms. Bhuya, there is a serious objection because of a stay order, maybe rightly so passed,
Yes.
but he has a grievance. So you file your replies immediately so that we can consider the issue. finally.
Lordship, we have already, in the instant case, we have already filed a reply, but since they have served copy on us minutes back, at least we need 4 weeks' time. Your
For what?
Lordship.
To file a fresh reply.
It's against their government affidavit.
No, affidavit, you have not filed a reply or you have already filed a.
The affidavit opposition filed by private respondent, we have already filed.
Okay, the government will also have
Yes.
filed now. So you file a reply. I'll give you
Yes.
2 weeks time, not more than that. On that, we will fix the matter and then we will consider.
My
2
lord,
weeks.
that will do, my lord. Lordship, what I pray before Lordship is that, my lord, if my lord, the final adjudication has not been taken place, my lord, it,
That you can always reiterate on that day.
or Lordship can, it may come
The
up.
IA
next
is,
vacating
IA
call.
is pending. IA is in here.
Considered, Lordship.
Let me see. There are 2 writ petitions.
My lord,
IA to some, IA to us.
3294. At page 21 is the interim order, my lord, which was expertise, my lord.
No, this was Madam Bhuya, this was not. Only he say, it was said that Mr. D. Nath Lana, senior government advocate, for the summit that he will receive instructions in terms of the order dated so and so during the course of the day. Accordingly, he prays that the matter be listed on 7/12. So we can consider that, no problem. Ms. B. Bhuya, Learned Counsel, Senior Counsel.
Considered, your Lordship,
No,
in the earlier writ petition. And court was not inclined to vacate the interim
forget it.
order.
Here, this writ petition, there is a stay order.
The Lordship will take up the entire issue, my lord. I was ready with the case today, but
Uh,
they filed the. Yes.
Genuine, your prayers, there is no doubt. That's why we are giving you time.
Lordship.
But Ms. B. Bhuya, Senior Counsel, appearing for the petitioners. Both cases, you are the petitioner?
Yes.
Ms. Bhuya submits that the state respondents have filed an affidavit in the matter in WPC number
659 of 2020.
Huh?
659.
659 of 2024 today. And accordingly, she she requires at least 2 weeks time to bring on record the rejoinder thereto on behalf of the petitioner. So, accordingly, the matter be listed again on (14/8/2024). Full stop. Mr. Bharvia has, J.I. Bharvia has appearing for the respondents have submitted that on account of the,
Can you
that
put
he is,
19, my lord, it's a Monday.
he is prejudiced, he is suffering in view of the fact that there is an interim order in operation. And accordingly, he submits that the matter be expeditiously, what is required to be expeditiously considered. Full stop. I have full stop in view of the above submissions of the Learned Counsel for the parties raised to list this matter again on 19/8/2024. Also, in the event on the next day of listing, the main writ petition cannot be taken up for final consideration. The applicant in IAC number 3294 of 2023 is at liberty to press the same for consideration before this court.
Lordship, interim order passed earlier.
Interim order passed earlier shall continue till the next date of listing. दोनों एक साथ मारते ना? None has appeared for the petition on call. However, for the ends of justice, registry to list this matters again on 8/8/2023. Yes.
Matter pertaining to non-payment of retirement benefit, these INs are for setting aside abatement and delay and substitution, my lordship, of the legal of the petition.
Where is that order? Wherein it has been held to be abated? ಯಾರು ಸರ್ ಮೀನ್ ಕೇಸ್
One, 1543 may be taken up, my lordship.
Where is the order alleged, violation of which is alleged?
Pardon, lordship.
Order, violation of which is alleged in the contempt page.
My lordship, in the contempt petition.
You mean to say this is Anamika Tamuli of the Soil Conservation Department?
Yes, my lordship.
List before, she was my client.
Yes, sir.
List before any other bench without me.
May I please your lordship? Lordship, may kindly see the last order, madam, at para 4, madam. Last order, madam, 17-7.
Last order, huh?
Otherwise, madam, this case, madam, I didn't contact madam. Para 4, madam. So, madam, on the first day, madam, your lordship had passed an order on 27-6. Madam, the order reads yes, madam, but so and so for the.
What is the clarification required?
Madam, but in the first paragraph, madam, it has been mentioned that I have taken 15 days time, madam. Madam, that person may be removed, madam. The first paragraph, madam.
What happened now?
But order has been complied, madam.
Complied,
Madam.
promoted.
Madam,
They have promoted
that's number
the
5,
private respondent.
5, madam.
So I have to challenge that subsequent promotion order as well as seniority. So that lordship will take up this matter after 3 weeks. In the meantime, my lord, because I need the DPC minutes, which they are not giving. Already I have filed an RTI application, my lord, perhaps within a short period.
This is that employment exchange.
Yes, employment exchange matter, my lord. Lordship was pleased to give them direction to follow the OM and.
We have complied the order, lordship order, madam.
In the.
So what is the mistake in this order, first paragraph?
My first line, madam, the order, order dated. madam,
Including the
27-6.
petitioner here would be considered by the Departmental Promotion Committee within a period of
No,
15.
Madam, order dated 27-6, madam. Madam, the first paragraph. There reads that, madam, that I have taken 15 days time, madam.
No, you said you had received instruction, you have produced some instruction
Yes,
before
yes,
me.
madam.
And therein it was said that within 15 days or something, they will hold the DPC.
No, madam, it has not said so.
They have held the DPC. Now what is the error there?
But this paragraph, madam, is pinching me, madam.
You file a review.
My lord.
File a review.
Madam, it has become influxes, madam.
File a review.
Madam, who will,
I can't touch this.
madam, who will sign, madam?
Your statement I have recorded. But if I have recorded that statement,
No, madam,
there
I-
has to be
Madam,
something
that-
somewhere.
To that, madam, I have made an objection, madam, that that DPC cannot be held within 15 days. You lost it, remember, madam. I made an objection, madam, that we cannot hold the DPC by 15. Anyhow, madam, the DPC was hold, madam. The order was
This
madam.
is-
But this paragraph made, madam, one word, madam. I have not mentioned such, so, madam. Now, who will sign, madam? They will not come for signing the affidavit, madam, for me. A single line, madam.
Yes, Mr. Das, what is left here in this case?
Nothing, madam.
My lord, everything was done pursuant to
No,
direction. from your
that we did not direct for your promotion.
One challenge, I have in the writ petition, my lord, I have challenged the seniority list also at that point of time.
Okay.
Now pursuant to, so that remains, my lord.
Wherein she was placed above you.
Yes, my lord, because this is the case wherein in the feeder cadre, my lord, all the officers belong to reserve category, my lord. Out of the 6 posts, 4 posts belong to reserve category. My lord, so that was, your lordship was pleased to direct that you do it as per the 2023 OM. That they have done against committing the same mistake, my lord. So
That
Okay.
new seniority has to be challenged along with the promotion given and the criteria is merit with due regard to seniority. Now they have followed seniority.
Cannot
Number
be.
one, they have given.
So you make a challenge to that.
Exactly,
We'll
that is
give you liberty. We'll close it. What is the point in continuing with this proceedings?
Only thing is my challenge that 10.
That challenge now, seniority has now been recasted. So
That's true.
Mr. H.K. Das, learned counsel appearing for the petitioner has submits that in pursuance to the directions passed by this court, the respondents have held the departmental promotion committee meeting for promotion to the post of Joint Director of Employment in terms of the provisions of the Assam Employment Service Rules 1989 and the private respondent number 5 has on being so recommended by the Departmental Promotion Committee has been promoted by an order dated 15/7/2024 to the post of Joint Director of Employment. So, Mr. Das further submits that although he has filed an RTI for being punished with the minutes of the DPC, which had led to the issuance of the notification dated 15/7/2024, the same has not been punished to him. So, in view of the above, the learned counsel for the parties have submitted that nothing further arises for consideration in the present proceedings, and the petitioner, respondents have submitted that nothing further arises for consideration in the present proceedings, and the petitioner, even if so, if petitioner has any grievance, he is to institute fresh proceeding, presenting the challenge to the recommendations of the DPC as well as to the promotion as affected in the case case of respondent number 5 hearing.
Also the seniority, please. I'm sorry.
Full stop.
I'm sorry.
Full stop. In view of the above position and it being the and taking note of the stand of the respondents hearing, the present petition would not be would not be required to be detained for further adjudication, and accordingly the same stands closed. So the respondents hearing would furnish to the petitioner the requisite information as sought for under the RTI Act 2005 within a period of 10 days from today.
That order may not come in this.
What?
That is a
How
design-
is it already 1 month?
RTI is
RTI. Date na lage. Full stop.
I'm appealing for private response number 6. That may be recorded.
We'll record your name. We'll record your name. You just give me your name. What is your name?
PM Taluk.
PM Talukdar, respond appears for respond number 9. Full stop. The petitioner would be at liberty to present a challenge to institute appropriate proceedings to present a challenge to the fresh seniority list as prepared of the incumbents in the cadre of Deputy Director of Employment, along with the recommendations of the Departmental Promotion Committee leading to the issuance of the notification dated 15/7/2024 and the notification dated 15/7/2024. Full stop. Mr. SP Das, learned counsel for the petitioner by drawing the attention of this court to the order dated 27/6/2024 has contended that therein it was recorded that therein a submission on his behalf was recorded to the extent that the Departmental Promotion Committee would be convened within the next 15 days. Full stop. Which he says is on account of a miscommunication arising in the matter. Full stop. Even if the same was so recorded on account of a miscommunication, the subsequent steps taken by the respondents for convening the meeting and taking the matter to its logical conclusion, any recording, the contention as recorded in the order dated 27/6/2024 of Mr. S.P. Das loses its significance in the matter.
But Lordship, may add one more line, my lord.
Ah,
On that day, my lord, I made, my lord, mainly, my lord, objection, my lord, regarding that, my lord.
enough. Mr. Das, you have got it. Whatever is required.
I'm for respondent 5.
Mr. Swenso for respond number 5. Mr. Das, you file appropriate
Yes.
application.
I'll have to file it immediately.
Do you want me to rewind the the video?
Yes, my lord.
On that day?
Yes, my lord. Yes, my lord. Yes, my lord.
We had a clear-cut discussion. I said
I
50.
made objection, my serious objection that DPC cannot be hold on within 15 days.
I have clarified.
The word has taken come, my lord.
I have clarified. And I don't think so. The respondents, anyway, less said the better.
Please.
That please, Lord. But the petitioner here is challenging the selection of Grampatan of Chief Gubernur.
Lordship can dispose of this petition, give a direction to the my lord, respond number 2 to dispose of the appeal within a stipulated time.
The appeal is pending.
Lordship.
Appeal is pending, Lordship. But similar order is.
Lordship.
I think I have passed the same order.
There is only the villages and the appeal number.
Yes, what is the appeal number?
Appeal number is 01/2024.
1/24.
What is your name?
My name is Roman Borman.
Roman Borman. No, your
B. Borgohain, Lordship.
huh?
B. Borgohain.
B. Borgo.
Lordship, Grampatan of Gubernur part number 1.
Ms. Taluda, you will be appearing for respondents number?
I am for 1 and 2.
Lordship, I am for 3, 4, and 5, Lordship, and I have received an instruction, Lordship.
And anybody appearing for the private respondent?
Respondent number 7 has refused the steps, Lordship.
Lordship, as per my instruction, Lordship,
Yes.
the prayer petition dated nil submitted by the petitioner was disposed of by the office speaking order issued by memo number 19/2000.
Appeal has been disposed of.
By speaking order, Lordship.
Please give me.
Lordship.
No, this is by your appellate authorities order has not come till now. This is by the deputy commissioner.
Lordship, KTDC, Lordship.
This is by the deputy commissioner, that will have no relevance. Appeal has not been disposed of.
Lordship, we were directing to the respond number 2 under the appellate. So we can
Just
dispose
now.
of this.
Respondent number, private respondent number 5. What is the
7.
Seven, Lordship. Respondent number 7.
what is the what is the charge number?
Chief,
Gaambura of which village?
Gubernur part number 1, Lordship. Page number 36, Lordship. Page number 36, serial is number 7, Lordship.
Govardhala, part 1.
Part number 1 of Tihu Revenue Survey.
Gobordal, na?
Gobordal.
OL or AL?
DAL.
DAL. पेज नंबर 36 बोल के लिख देना तो ये जो विलेज का नाम है यहाँ पे सीरियल नंबर 7 ना.
It's serial number 7.
What is the appeal number?
1/24.
Before the Director of Land Records and Survey. 162. So the director to be considered as a director to consider the appeal number 1. 5 hearing would be outright for the appeal number. Okay. Dispose of. ये लिखा तो गोबारा GOBARADAL मतलब part number 1 village है so and so वो बीच में तुम्हारा वो आ जाएगा सेकंड पेज में देखो नीचे में गोबरडाला बोल के लिखा है डिस्पोज pending was in yes.
Well, the direction of the honorable court is to dispose of the appeal. Well, that has been disposed of. They have passed an order on 8/7/2024.
What should that be recorded?
Heard the learned counsel for the petitioner, also heard Mr. D. Nath, learned Singh, learned counsel appearing for the respondents. Mr. Nath has submitted that the order, violation of which has been alleged in the present proceeding, has since been complied with by the respondents. So, this court-wide order dated 6/11/2023, passed in WPC number 6361/2023, had required the Commissioner of Police Guwahati to dispose of the appeal dated 31/7/2020 filed by the petitioner within the time frame prescribed therein. So, Mr. Nath has produced before this court. Also, Mr. Nath has produced a copy of the order dated 8/7/2024, passed by the Joint Commissioner of Police in charge, appellate authority, Police Commissionerate Guwahati.
He is the appellate authority.
In terms of the directions passed by this court, wide the above noted order. So, in view of the above position, the order, the directions passed by this court, wide order dated 6/11/2023, having been complied with, there were no further adjudication would be called for in the present contempt petition, and accordingly, the same stands closed. A copy of the order dated 8/7/2024, as furnished by Mr. D. Nath, learned counsel for the respondents, is kept on record and marked as X. এইটো চাবা এইটো আমাৰ কিমান 58 কৰিলো নেকি এইটো জন আছে এইটো কিমান আছে
49. We have no issue with lordship disposal to
what did they dismiss as it?
Sir, Lordship, I have submissions for 50. Lordship, in item number 50, Lordship, Mr. ARBI is the leading counsel and today he is absent, Lordship. So let the matter become up.
No. Today, if it has to cross over, cost or dismissal, choice is yours. Clear-cut order, 1 month time was given you to take steps. You have not taken. Why should we?
Lordship, then may I clear Lordship, humbly said, Lordship may allow us to take steps.
No
imposing
further. No further.
Minimal
No.
cost, Lordship.
Minimal cost would be 50,000 to the Bar Association,
Chip.
Benevolent Fund. So let the bar get some money. or dismissal. Or argue the matter today. We will PF. 3 options. Not decided. And madam, you want the matter to be closed. We'll record your submission.
Send them the information, but
Heard Miss Deb,
Yes, Dev.
as the learned counsel for the petitioner who submits that this court will be pleased to close the present petition in as much as the petitioners hearing have not been responding to the have not been responding to the on the prayer of the parties, list this matter again tomorrow. Sub by slip. We'll dispose of it on merits.
Okay.
And if you take steps also today, it will be subject to 50,000 cost acceptance. Duta ekal again, 4950 by slip query. List this matter 4950, list this matter again tomorrow for tomorrow, that is 30/7/2024 for further consideration. Thank you.
Lordship, the conducting counsel with the M. Sharma had to rush to the hospital, my lord. There is a medical emergency. My lord may give us some time. It takes another day. It's already part 1.
I've heard you. Yes.
Lordship, actually, my senior Mr. Samaria also left the court premises due to some urgent.
Oh. Day after tomorrow.
Lordship. Day after
As
tomorrow.
prayed to by the parties, list this matter again. Day after.
Lordship may kindly grant us some time because Mr. Sharma.
We don't want Mr. Sharma until and unless Mr. Samaria brings something very great on record.
Okay.
And Mr. Counsel, last time also I told you, show this court how the criminal order's nature can be gone into.
Lordship.
When you have terminated him because of his conviction.
Yes, Lordship.
That conviction having been interfered by this court,
Yes, Lordship.
that whole thing goes.
Lordship.
Your order is also become null and void.
Yes, Lordship.
So he is entitled. You have not drawn up any departmental proceeding against him. He's entitled to all the benefits. That's all.
Lordship.
Right?
Lordship. Day
So
after-
satisfy me on that issue. Otherwise, we are passing on this.
Lordship.
Day after tomorrow.
As per last order, I was supposed to file the affidavit in opposition. I have filed it today.
So you were supposed to file it by
On 24th, yes, it was.
So
but-
for this 2 days delay, how much will you pay?
Actually, the BSNL, the person who signs it.
Oh,
was-
BSNL. Then we will have to impose. Yes, Mr. Dasan. Do you want to file any reply to that? No. We'll consider it for hearing Thursday.
Thursday is the BSNL matter. I have some doubt whether your lordship can take it up or not.
Why?
The service matter.
Huh?
Pension matters, BSNL pension matters. Nile is central administrative will take some.
Huh?
Whether it should be
Yes,
educated in CAT or not, that's.
BSNL, that
That
is,
is the
that is
thing which
another
also-
issue also.
Yes, that is.
Yes. That is a very
Also,
relevant issue because
that
you.
I have also not
Don't
taken
take
it
it to the over.
Thursday.
You will have to go to CAT
CAT.
because the jurisdiction is vested in CAT.
So whether it can be transferred to them, they are not on that.
No. You will have to withdraw and fight. Transfer would have occasion when the act came in. After that, transfer is not. Should not be done.
That is my endeavor, I've done nothing else.
And you
Yesterday I
have
checked
taken
it
that
out.
plea
No, I have.
Let it Thursday,
Thursday,
Yes.
on that
as
day,
prayed for by Mr.
on that day, we should check it up. whether
I
it can be
just,
done.
I'll also go through, but I think it's cat.
Please,
So and
it
so,
can be
Mr.
transmitted, it will
Dasgupta,
be
A. Dasgupta, Learned Counsel, appearing for the petitioner, submits that the matter be taken up again on Thursday to enable him to examine the issue as to whether the said present writ petition would be maintainable in the before this court. Mr.
No, so far, Mike said, it should not be recorded. Please.
Okay, sorry.
Go
Mr.
ahead.
RJ Das, Learned Counsel, usko karo. Mr. RJ Das, Learned Counsel for the petitioner. For the respondent submits that the affidavit on behalf of the respondents have been filed today.
let it-
Accordingly, list this matter again on Thursday for.
Otherwise, it will create some problem.
I got it.
Deeply
Thursday, Thursday.
May I please, your lordship, on last occasion, lordship asked them to take instruction regarding what order passed after the submission of inquiry report in 2014, lordship. Inquiry report is page number 47, 48, lordship. And 49.
Yes, Ms. Vatsaji, what is it?
The instruction, but they have not passed. I think they have misunderstood these things. They are continuously pushing this SPCID to give us the final these things, lordship. Otherwise, inquiry was completed in 2013 itself, lordship.
What is this?
The petitioner was, I think, in present.
Who had conducted this?
Lordship, inquiry report, page number.
Additional Deputy Commissioner. Now, what is this SPCID to do here?
Lordship, as the case is pending in the SPCID,
That is
lordship,
criminal
yes,
case.
lordship. I told them, lordship.
Any charge sheet filed against her? Then?
As per my
In this inquiry, nothing, lordship. Subsequently, I think,
So.
yes, lordship.
In terms of the directions passed by this court while order dated 27/6/2024, Ms. Vatsaji has placed before this court a communication received by her from the District Commissioner, Hailakandi, wherein it has been contended that as the final inquiry report from SPCID Assam is still awaited in order to finalize the inquiry against so and so filed against in order to finalize the inquiry against the petitioner. Full stop. It has been received that the inquiry report as indicated in the said communication dated 27/6/2024 pertains to the criminal case so instituted against the petitioner and it is
5 of 2013.
and it is stated in the bar that there is no charge sheet has been filed till date by the respondent authorities. However, from the records of the writ petition, it is clear that an inquiry report has been submitted in the departmental proceedings so instituted against the petitioner on 10/10/24. However, the same has not been taken to its logical conclusion. The disciplinary authority of the petitioner, that is the District Commissioner Hailakandi, is now directed to take on record the said to pass appropriate orders on the inquiry report submitted against the petitioner herein within a period of 2 weeks from today. The order that would be so passed would be placed before this court on the next date of listing. It is directed that the inquiry being independent, department proceeding being independent of the proceedings in the criminal case so instituted against the said petitioner, the materials, the progress as made in the said investigation would be of no consequence for taking the departmental proceeding to its logical conclusion, inasmuch as the inquiry in the departmental proceeding has since been completed and the inquiry report submitted.
Lordship, it is in my favor in the.
Oh, they'll have to take a decision, madam. How will they? So list this matter again on 10 days, there, na? Take a decision within, itna nahi diya. 2 weeks, 15 days, 2 weeks, 15 days. List this matter again on 19/8/2024, on which date the district commissioner shall invariably place on record the order as passed in the matter by him on perusal of the inquiry report and the materials brought on record in the inquiry.
The last occasion, my lord, the departmental records, proceeding records of two other petitions. Call for.
Oh, now producing also will not do. 445. So some other day. As prayed for by the Learned Council for the parties, list this matter again when next week, Tuesday, 6/5/6/8/2020.